We'll take a look at what I proposed. You're not objecting to the wording. Your issue is placement.
That's it.
All right, let's just take a minute to take a look at it. I essentially adopted 99% of his suggested language.
And I'll say I used his document at the end of the day and just moved that around. That's it. I looked through the statutes. It seemed there has been a scintilla of evidence. It seemed like this is coming in, so the rest is appropriate.
Sure. Yeah. Yeah. That was supposed to be Yeah, you should actually remove that. All right, when you all are ready, let me know. I can go back on the record. I reviewed it. I have some modifications.
Whenever you're ready.
Let's go on the record, Gabriella. All right, back on the record. Mary Louise, I'm going to ask you to enter this as court exhibit, whatever number it is, the first draft of the jury instructions.
Court exhibit is going to be court exhibit 2.
Can you also mark this as court exhibit 3, which I have it back? It's the second draft of the jury instructions, so that's going to be number 3. Yes. And then can you also mark this as court exhibit 4? This is defense's proposed jury instruction. I don't think it'll be an issue, but I want marked, and then it can just be court exhibit 5. That's going to be the state's proposal. All right, go to page 8 of my second draft of the jury instructions. I just want to make sure you all have taken a look at it. I'm concerned with that big paragraph that has language in the negative. So if both sides have reviewed it, I've reviewed it. I don't think there's any typos or any grammar issues.
I mean, it is off of the standard.
It is.
Wording.
I added burglary and or false imprisonment. That language is in there. Towards the end of the paragraph, it talks about retreating, being futile. Before that, it talks about herself and or others and it would have increased her own danger to retreat. So I just want to make sure that wording is acceptable to the parties.
Yes, sir.
All right, let's move on
Yes, Your Honor.
And Mr. Altala, I'm going to leave the placement of the burglary and false imprisonment definitions where they are, only because we have the wording of false imprisonment and burglary after that big paragraph.
I believe that's what I was
Oh,
suggesting, Your
all right.
Honor. It was Mr. Tomas's draft that was added a little farther down.
Okay. Burglary, my definition doesn't include the intent to commit a crime therein. I'm going to add in false imprisonment, which is what Mr. Tomas has.
Yes.
So let's move down to the definition of false imprisonment, to the definition of secretly, where I have victim in parentheses. Mr. Tomas, you have the defendant, right?
Yes.
Should it also have the minor children?
Yes.
So it should have defendant or minor children?
Yes.
Okay. Can it have defendant or minor child or minor children?
It can, or defendant or another, but defendant or minor children is fine.
Having minor children, I prefer to show it should be another, the defendant or another.
Yeah, but who was in the house that she says she was afraid for? The
But-
kids, right?
They're already having an instruction at the very next sentence going, confinement of a child under the age of 13. It's already addressing that, so it should just be the confinement of the defendant or another.
Over your objection, I'm going to have minor child or minor children.
Understood?
And wherever you have the word Daisy Link, I just have defendant, just to keep it uniform, because that's what I have in other parts of the jury.
That's fine.
Okay. If there's no other suggestions, I'm going to move on to the other parts of the jury instructions.
I have no other suggestions for this portion.
All right, let's go to page 1. The cover sheet is standard. Page 2 is the statement of the charge. There's a typo there, crimes versus crime, I'll change that. introduction to homicide, justifiable homicide, excusable homicide, those are also standard instructions.
Again, are we good for?
Yes, no, on page 3, just review it to make sure you don't have these other suggestions. All right, we can move on to page 4.
On page 4, the state does have a proposal.
Okay,
On line 2, where it says death is caused by the criminal act of, I believe it should say Daisy Lynn instead of defendant.
I'm just gonna keep it. Why? I'm just gonna keep, wherever it says Daisy Lee is now defendant.
Well, we've already substituted victim for Pedro Jimenez, it should be defendant substituted for Daisy Lynn.
Remember at the statement of the case, on page 2, Daisy Lee, the defendant in this case. So they know from page 2 on, everywhere that it says defendant, it's Daisy Lee.
Understood, just making a suggestion.
All right, let's move on to page 5, lesser included crime. Couple typos there. All right, there's a couple E's where they should be she's, the crimes should be crime, singular, and
Does it need to say that we need crime since it's just one?
yes.
Okay.
So I'm going to change that. This is another suggestion, I'm going to move on to page 6, the definition of manslaughter. Okay, we'll move on to page 7, aggravation of second-degree murder or manslaughter by carrying or using a firearm. Should it be used instead of carried?
Be carried on board use.
I agree, it should be both.
Mr. Tomas, I'll leave it carried or used.
That's fine with me, Judge.
I'll move on to page 8. You already went over?
Page 7, should we, I know it's giving the definition for the term firearm, but should those be in parentheses like that?
That's how the standard instruction is. I can remove it if you want.
Yeah, normally in the past I've removed that, you know.
Which part, starter gun or the?
Well, no, not the entire sentence, just the parent, like the brackets
Okay.
itself.
I'll remove those. The brackets, all 4 of them. Page 11, parental rights. As well as the use of transcripts of recordings.
Regarding this page, Your Honor, the state did submit motion for Your Honor to take judicial notice. The state has done a diligent search trying to see if there were any type of court records of an injunction for protection from domestic violence or written pre-trial supervision order of no contact against that person. Looking at the clerk's website, there was no case active between Pedro Jimenez and Daisy Lee. So the state is requesting the court to take judicial notice of those lack of documents and that it does not exist. Similarly to the parental rights instruction.
Judge, that's not appropriate. First of all, there wouldn't be any notice because those records are not public. As the dependency case was not public, there's an order which addresses the custody status, and that is the most recent order. That is in evidence.
Your Honor, injunction violations are public, and actual like arrest forms where there are pretrial services conditions are public as well too if there is a case against the two.
Aren't the pleadings closed? Whatever's in evidence is in evidence. Whatever I've taken judicial notice of, I've taken judicial notice of, right?
Your Honor, you haven't read to the jury at any point in time this judicial notice regarding parental rights, and we did suggest it towards the beginning. And we are introducing the actual court transcript as well too, to the jury when they come back into it.
Well, there's a document from the dependency court limiting Mr. Jimenez's visitation of the children, right?
Yes.
Okay. And I already took judicial notice that there's no records in Miami-Dade County terminating the parental rights, right?
Yes, Your Honor.
So that's my point. At this stage, you want me to take judicial notice of other court actions,
That's correct.
so the pleadings are closed. Why should I do it at this stage?
Well, Your Honor, because it is essential for the actual justifiable use of deadly force jury instruction that's here. And if you go specifically to page, just one moment to go up. We go to page 9 and 10. It talks about the presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person against whom defensive force is used has the right to be in, or is a lawful resident of the residence, such as an owner of lease or title holder, and, meaning you have to have both of these exceptions, there is not an injunction for protection from domestic violence or written pretrial supervision, order of no contact. Without that instruction here, Your Honor, and since those documents don't exist, the court, the jury should be able to rely on Your Honor's judicial notice saying that that does not exist here to see that that presumption of reasonable fear of imminent death does not apply here in this case.
So you're going on page 10, right?
Yes, I say 9 and 10 because it starts before where the rule is created and then and
So-
it's the exception.
So it's A, B, C, or D.
That's correct.
Okay. Are you planning on arguing that there's nothing in evidence regarding the injunction of protection from domestic violence?
I wasn't going to talk about that at all.
Okay. I'm having a hard time because the pleadings are closed. You want me to take judicial notice, essentially of a piece of evidence that no one has brought up until now. And the only issue that came up during trial was the limited supervision of the victim. And there's actually a piece of evidence, including testimony that corroborates that. So that's the issue I'm having now at this juncture. Plus A, B, C, D, there's an or between every single paragraph.
Well, then if it's not being argued by defense, then would there be a stipulation then to remove that portion regarding the presumption of fear?
Absolutely not. Nor should I.
Let me give you an example. Vehicle is also discussed in the standard jury instructions. There's no evidence that there's any forcible entry of a vehicle, right? So there's language in here that's extra. It's just for the consideration of the jury.
And the jury should be able to consider this as well too, Your Honor. That's just a state's position.
Over your objection, I'm not going to take judicial notice at this stage of the proceedings. What about the language regarding parental rights for the piece of document that's already in evidence?
Your Honor, the state agrees with that.
All right, defense.
Which part are we talking about?
Page 11.
No, that's one.
Okay. And what about the use of transcripts of recordings?
Your Honor, I do believe you should insert Rule 2.2 here, which is instructions on edited recordings before the use of transcriptions and recordings.
All right, we can add 2.2. Just reminding them that they listened to something that was edited?
Yes, Your Honor.
All right, what about use of transcripts and recordings?
That's appropriate.
Fine with
Defense.
me, Judge.
I'm going to let them know that it is an item that is in evidence regarding the transcripts.
Yes, ma'am.
All right, page 12.
It's like the standards.
It is a standard. All right, page 13. All right, tell me 6, 7, 8, 9, and 10, which ones you all want? 6.
Yes, Your Honor. 6 should be included.
Defense.
I'm not sure what has been introduced during this trial to justify this instruction.
Can you think of anything?
Your Honor, so PJ did testify during his testimony that he said he's here to get his mom out. And then he was asked, do you know where your mom is? And it was suggested jail. That is the other benefit here in order to get the witness to testify, and that did come out through his testimony.
You can still argue that without arguing.
But it should be something, a rule that, without the instruction, that's not something that the court can consider. And that's routinely said in closing arguments. Everything that's in this
Look, I'm
packet.
gonna leave 6N, but you can argue credibility, what he said, what he didn't say, and other things surrounding his testimony. I'll just leave 6N over the defense objection. 7, pressure or threat. Now this is where the PJ argument comes in. All right, there's no objection, I'm gonna leave 7 in. 8, there was some attempts at impeachment, I'll leave 8 in. 9, there's no evidence of convictions of felonies or misdemeanors.
Agreed, we should take it out.
10, there's no evidence of any general reputation evidence.
Agreed.
Fifteen is a blank page, I'll change that. Page 16, defendant statements.
That's the standard, that's fine.
It's the standard. All right, rules for deliberation, that's also standard on page 17. Page 18, cautionary instruction is the standard. 19 is also the standard. Closing argument is standard, submitting case to the jury is standard.
Judge, just a suggestion, on page 19, the last paragraph, should it say the crime charge since there's really only one?
To the crime charge,
Yeah.
instead of each crime charge, to the crime charge.
Yes.
Okay, I'll change that. Okay, I'll be back. Just give me a few minutes. The set will bring me down to the revised third draft. Thanks.
And Your Honor, I don't know if you want page 22 on a separate page.
I can figure out how to make it go up. I'll see that. All right, folks, I'll be back.
All right.
look at the pages where we made the edits. Acceptable to you all, I can have to fire off 9 copies to the jury, at least. This is all going to be on court exhibit as number 3.
I apologize, I'm still going through each page.
No, what did you say?
I'm sorry, whatever court exhibit needs to be.
6.
I'm going to give you back these court exhibits. At least I'm giving back these.
Do you mind moving some stuff around? Thank you. Your Honor, this might be my move, but on page 9, just for reading it, after it says confinement of a child by sentence, it jumps into deciding whether the defendant is justified. I mean, visually, I would think that there would need to be an extra space between the two. It kind of looks like a continuation of the false imprisonment. I don't want there to be any confusion, but
Defense on page 9, is that your request? An extra space.
I mean, an extra space, or just start that at the next page, and find either way.
yeah, either or.
All right, I'll do an extra space. Is that all?
I'm almost done, but that was it on that page. either. I have no other issues, and as well with the verdict form.
All right, defense?
No issues, Judge. I don't have a verdict form.
I emailed it last night.
Oh.
There's one little typo, I'm gonna do it in 2 pages, you can have mine. Well, then, we'll start following. Okay, I'll make those changes, I'll come back with probably 15 copies, and feel free to call Chambers if you all see anything else you want me to change. I'll be back.
All right.
We should
Come on, he stepped out for like 2 seconds ago.
Let's go ahead and get him. He might be in the bathroom, or he might be, Gabriella. Guys, let's try to figure out, can someone help me with that static noise?
We're trying to figure that out.
Did someone move that podium, Marilise?
It's not this one.
I really wasn't doing that before, honestly.
It's our one you stepped out randomly.
We're trying to figure out which ones are each up. Alright, Gabriella, if you can't figure it out, I'm gonna get myself another courtroom. I'm gonna get myself another courtroom if you can't figure this out in the next 2 minutes. It's fine, starting at 9 a.m. this morning, now something's going on. Do me a favor. Ask across the hall, if I need one of the courtrooms.
2-2, I want 5 sheets off the bench.
Let's check for 2 across the hall.
It's channel 8, but I don't know the numbers of like which mic can switch
Is it channel 8? This one. This wire is to get recorded.
It's the wire.
I don't know how.
Yeah, it's the wire on this one.
Okay, move it around. Maybe if you move it around.
Another split. That one? I don't think so. It says the courtroom TV is muted. Not that I'm aware of. No, it's muted.
I now instruct you on the circumstances that must be proved before the defendant may be found guilty of second-degree murder or any lesser-included crime. Second-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Pedro Jimenez is dead. 2, the death was caused by the criminal act of the defendant. 3, there was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Lesser-included crimes. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser-included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser-included crime. The lesser crime indicated in the definition of second-degree murder with a firearm is manslaughter. Page 6, the definition of manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Pedro Jimenez is dead. 2, the defendant intentionally committed an act or series of acts that caused the death of Pedro Jimenez, or the death of Pedro Jimenez was caused by the culpable negligence of the defendant. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, which caused the death. I will now define for you culpable negligence. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to do harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. For negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or grossly careless disregard for the safety and welfare of the public. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant knew or reasonably should have known was likely to cause death or great bodily injury. 7, page 7, aggravation of second-degree murder or manslaughter by carrying or using a firearm. If you find that the defendant committed second-degree murder or the lesser-included offense of manslaughter, and you find beyond a reasonable doubt that during the commission of the crime she personally carried or used the firearm, you should find her guilty of second-degree murder or the lesser-included offense of manslaughter with the firearm. A firearm is defined as any weapon, including a starter gun, which is intended to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. If you find the defendant committed second-degree murder or a lesser-included offense of manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried or used the firearm, then you should find her guilty only of second-degree murder or the lesser-included offense of manslaughter. Justifiable use of deadly force on page 8. It is a defense to the crime of second-degree murder, including the lesser-included offense of manslaughter, if the actions of the defendant constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. The defendant does not have the burden of proving that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. The law on justifiable use of deadly force is as follows. Defendant was justified in using deadly force if she reasonably believed that such force was necessary to prevent A, imminent death or great bodily harm to herself or another, or B, the imminent commission of burglary or false imprisonment against her or another. If the defendant was not committing any crime other than the alleged second-degree murder or any lesser included crime for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had a right to be, then the defendant had no duty to retreat before using deadly force. On the other hand, if at the time the defendant used deadly force, she was committing second-degree murder or manslaughter, or if at the time the defendant used deadly force, she was not in a place where she had a right to be, the defendant had a duty to retreat. The duty to retreat means the defendant had the legal obligation to use every reasonable means to avoid danger before using deadly force. The law does not require the defendant to retreat if she was placed in imminent danger of great bodily harm or if she was placed in imminent danger of death or great bodily harm, of imminent danger of the commission of burglary and or false imprisonment against herself and or others, and it would have increased her own danger to retreat, or if retreat, it would have been futile. But if the defendant had a duty to retreat and she could have safely retreated, but did not do so, then her use of deadly force was not justifiable. If the defendant was in a dwelling or residence in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to herself or another, or B, the imminent commission of burglary or false imprisonment against herself or another. Burglary is defined as follows: entering a dwelling owned by or in possession of another, and at the time of entering the dwelling, the unauthorized person had the intent to commit the crime of false imprisonment. Dwelling means a building of any kind, whether such building is temporary or permanent, mobile or immobile, which has a roof over it and is designed to be occupied by people lodging therein at night, together with the enclosed space of ground and outbuildings immediately surrounding it. The enclosure need not be continuous, as it may have an ungated opening for entering and exiting. For purposes of burglary, a dwelling includes an attached porch or attached garage. False imprisonment is defined as follows: to forcibly or secretly confine or abduct another person without lawful authority to do so. Secretly means the defendant intended to isolate or insulate, secretly means the victim in this case, Pedro Jimenez, so that's a typo, intended to isolate or insulate the defendant and or the minor child and or the minor children from meaningful contact or meaningful communication with the public. I'll repeat, that was a typo. So secretly means the victim in this case, Pedro Jimenez, intended to isolate or insulate the defendant and or the minor child and or the minor children from meaningful contact or meaningful communication with the public. Confinement of a child under the age of 13 is against the child's will if such confinement is without the consent of the child's parent or legal guardian. In deciding whether the defendant was justified in the use of or deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances must have believed the use of deadly force was necessary. The defendant is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another when using defensive force that was intended or likely to cause death or great bodily harm to another if the person against whom the defensive force was used in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle, and B, defendant knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. The presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person against whom the defensive force is used has the right to be in or is in a lawful resident of the residence, such as an owner, lessee, or title holder, and there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person, or the person or persons sought to be removed as a child or grandchild, or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used, or C, The person who uses defensive force is engaged in a criminal activity or is using the residence to further criminal activity. Or D, the person against whom the defensive force is used is a law enforcement officer who enters or attempts to enter a residence in the performance of his or her official duties, and the officer identified himself or herself in accordance with any applicable law, or the person using the force knew or reasonably should have known that the person entering or attempting to enter was a law enforcement officer. A person who unlawfully and by force enters or attempts to enter another's residence is presumed to be doing so with the intent to commit an unlawful act, force, or violence. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporary or permanent or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Residence means a dwelling in which a person resides either temporarily or permanently, or is visiting as an invited guest. Vehicle means a conveyance of any kind, whether or not motorized, which is designed to transport people or property. If you find the defendant who, because of prior threats or difficulties with Pedro Jimenez, had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Pedro Jimenez, you may consider this fact in determining whether the actions of the defendant were those of a reasonable person. On page 11, in considering the issue of self-defense or defense of others, you may take into account the relative physical abilities and capacities of the defendant and Pedro Jimenez. Parental rights. This court has taken judicial notice that there are no court records in Miami-Dade County terminating the parental rights of Pedro Jimenez. Instruction on edited recording. You heard a video recording. The court instructed you that the recording had been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording had been edited should not concern you in any way and must not impact the way you view and listen to and consider this evidence. Transcripts of recordings. During this trial, you heard a recording and you are now being furnished transcripts of the recording. The recording is the evidence, and the transcripts are provided to you only as a guide to help you follow as you listen to the recording. The transcripts are not evidence of what was actually said or who said it. If you notice any difference between what you hear on the recording and what you read in the transcripts, you must rely on what you hear and not on what you read. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, and the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Page 13, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence you should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than others. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the case? Has been offered or received any money, preferred treatment, or other benefit to get the witness to testify? Had any pressure or threat be used against the witness that affected the truth of the witness's testimony? Did the witness at some time make a statement that is inconsistent with the testimony he or she gave in court? Whether the number of witnesses it is called or upon the number of exhibits it is, but instead witnesses employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of the expert's testimony. You have heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about the testimony of what the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or testimony of any witness. Defendant's statements. Statements claimed to be made by the defendant outside of court have been placed before you. Such statements should always be considered with caution and be weighed with great care to make certain they were freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statements were knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether the defendant made the statements, she had been threatened in order to get her to make them, and whether anyone had promised her anything in order to get her to make them. If you conclude the defendant's out-of-court statements were not freely and voluntarily made, you should disregard them. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice, and there is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. And the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proved guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. And deciding a verdict is exclusively your job. I cannot participate in that decision in any way, so please disregard anything I may have said or done that made you think I preferred one verdict over another. Page 18, verdict. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned to the crime charged. The verdict must be in writing, and for your convenience, the necessary forms of verdict have been prepared for you, and they are as follows. It's pretty simple. Page 2 is the date and the jury foreman. You don't have a copy of this, but I'll hold it up. So it's really a one-pager. You have three choices: not guilty, guilty of manslaughter as a lesser included offense, or guilty of second-degree murder. If you find Ms. Lynn guilty of any of the crimes, there are interrogatory findings regarding the firearm. So you have to make a finding for the manslaughter. If she actually used the firearm, yes or no are your options. Similar options for second-degree murder. You'll have the options of whether or not she actually possessed the firearm during the commission of the offense. Also options of yes and no. You'll then go to number 2, did she discharge the firearm during the commission of the offense? Then you'll go to number 3, did she discharge the firearm causing death during the commission of the crime? It's pretty self-explanatory. And as I said earlier, the lawyers will have an opportunity to make their closing arguments to you. The state gets to go first. And for the state, we have...
May I please report?
Yes.
Counsel. Ladies and gentlemen of the jury, on June 25th, 2022, Pedro Jimenez was murdered. He was murdered by his 9-year relationship, his spouse, his wife,
this defendant, Daisy Lane. Earlier that day, Pedro Jimenez was picked up by friends. Miss Link knew that. He went over there and was there for a very long time. And that made Miss Link angry. He wasn't home, he wasn't spending time with her or his children, he was with friends. He's a trucker, he's never home. Why aren't you spending time with me? Her mother's there. Her children are home. Her mother flew in for a barbecue. Why aren't you spending time with me? And so what does she tell her mother? I'm gonna go pick this idiot up. He's probably drunk off his ass. And she goes. She's not afraid. She goes there, unafraid, uninvited. And she waits outside, and minutes pass. And she asks Pedro, where are you? And he doesn't respond. And so she goes inside to look for him, unafraid, not scared, uninvited. She sees him, and he says, I'm coming, I'm coming. And she pulls him out of the house and takes him home. Their home. Not her home, but their home. And then they go and get beer. And they continue acting like a family, a toxic family. No doubt about that. We were the first ones to tell you it was a toxic family. We're the first ones to speak, we're the last ones to speak. It is our burden. But we were very upfront with you, ladies and gentlemen of the jury. This is a toxic relationship. Two people that should have never been together. Ms. Link said Pedro Jimenez was a good guy. I disagree. I don't think he was a good guy. But he didn't deserve to be murdered that day. And so they fight. Why? Because Pedro has his suspicions. He accuses her of cheating. He's never home. This is his wife of 9 years. And he accuses her of cheating. And she denies it. And they continue fighting. And then he backs off. And he accuses her again. And they fight about that. And then he backs off. And they continue fighting. Over and over again. Until Pedro gives up and leaves. Miss Link already had the gun at that point. And she goes outside to smoke her cigarette. And Pedro comes home. And she sees him. And she says, you know what? I'm done with this. You're never home. You're not around our kids. My mom's here for a barbecue. Which, mind you, happened earlier that day that he missed. You know what? You're right. I did cheat on you. And what does Pedro say? She's holding the gun at that point. He says, as she's pointing the gun at him, do it. Do it then. I want to die. I gave you everything. His voice drops. He turns and starts walking away. And then he realizes, as the gun is pointing at him, that Miss Link is serious this time. We heard that they were a toxic relationship. He hit her just like she hit him. And he started to run. And she fired. And it went through his foot in an upward manner, through his thigh, hitting his ephemeral artery. Pedro had cocaine in his system, yes. He had alcohol in his system, yes. He had marijuana in his system, yes. But we heard from Dr. Mathis that coke actually kept him alive. He would have died faster. And so what does Daisy do? She mocks him, belittles him. It's not like I hit a major artery. You'll be fine. A couple seconds pass. As he's running away, fleeing from her, he's the one in fear. You sure you don't want to go to hospital? No? Okay. And then she tosses the gun. She goes back to where she shot, and she picked up the casing that was never found.
Objection, fact not in evidence.
So this is argument of what the lawyers believe the evidence showed you. You should rely on your memory of what the evidence was. You can continue.
And And then Daisy realizes, wait, my neighbors heard that gunshot. Let me go see where Pedro is. And she goes looking for him. And she doesn't call 911. And she finds him. And he's laying on the ground. He had been running, hiding in bushes, scared. And she finds him, and what does she do? She goes up to his body as he lies there dying, begging for help, asking her, pleading her, call 911.
Objection, facts not in evidence.
Sustained.
And she goes through his pockets, takes his phone, takes his identification, and walks back to the car. And she hides that stuff because she doesn't want anyone to know who he is. Because if they find out who he is, they'll figure out she was the shooter. And so finally she walks back and starts rendering aid because she realizes what's about to happen. He's about to die. And so that is the time that she calls 911. And she lies to the 911 operator. She says, I have no idea who this person is, despite being married to him for 9 years. I don't know what his date of birth is. I don't know how old he is, despite being married for 9 years. I just found this random man. I was walking around in the alley, despite being married to this man for 9 years. Officers arrive, and she asks, Pedro, what happened? What the fuck happened? She knew, and she lied, and she lied, and she lied. Officers were kind to her. They let her go back to the home. This is a spouse. She's scared. They didn't know what was going on at that time until Detective Danny Morales shows up. Seasoned homicide detective. And he sees a woman in the middle of the area. He doesn't know who she is, and he approaches her, and she becomes aggressive. In fact, that night she threw a chair at him. And so he detains her, and as he detains her, as he pats her down, trying to calm her down, trying to get a hold of the situation, she starts hiding the keys in her pocket. The keys of that same Chevrolet Trax with Pedro's stuff in it that would identify him, that would link her to this crime. Eventually they bring her to the homicide headquarters. She never denies that they lived together, never denies that he lived there, never denies their relationship. Changes her story over and over and over again. Listen to it, it's an hour and a half long. An hour and a half of changing statements, of changing stories, giving more detail, taking that detail back. We gave you a transcript as well. Read it over. She changes her story over and over and over again. Officers find a firearm, that same firearm that belongs to her. The same firearm that she used to kill Pedro. And that night they arrest her. But that's not where their investigation ends, ladies and gentlemen of the jury. They continue investigating. They find surveillance video that disproves what Daisy Wayne was saying. That shows Pedro fleeing, hiding, in fear. And they take it back and they try to download it. And because of the program, when it gets plugged back in, it gets deleted. And that's a shame. But it wasn't deleted on purpose. We heard the steps that they took to preserve that evidence. And old technology is old technology. That this defendant murdered Pedro Jimenez that night. So as we heard jury instructions read to you earlier, there are some rules of deliberation about how you should weigh the evidence in this case. And I want to walk through these 8 rules with you all and talk about the state's witnesses first and how you should weigh this evidence. Number 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? Yes. Every single state witness was personally involved in this case or was there the night of the murder, investigated the case. talked about what they did. Each and every state witness didn't say, well, I wasn't there, I don't know what was going on. Everyone was there. Every state witness testified to that. Kevin Bonilla was at the house when Daisy showed up and walked inside to go pick Pedro up. All the detectives were on scene. Canine officers who found firearms. Everyone there saw and testified to what they did. Did the witness seem to have an accurate memory? Yes, they did. It's 3 years ago, sure. But they remembered what they did. They remembered their investigations. Was the witness honest and straightforward in answering the attorney's questions? Yes. This is a trial. There are objections. Some are sustained, some are overruled. Absolutely. But not a single state witness gave a sarcastic comment. Not a single state witness argued. Everyone was very candid with what they did, what they didn't, what they remembered, and they were honest and straightforward the entire time. Did the witness have some interest in how the case should be decided? No. 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 Does the witness's testimony agree with the other testimony and other evidence in this case? Absolutely it does, and we'll walk through the evidence in a few moments, but absolutely it does. Each step officers took agreed with the next step. They talked about how homicide teams work in teams, that there is a lead. That lead gives assignments. The blood trail is consistent with the video that Mr. Cisneros saw, that Detective Morales saw, that Detective Hubbard saw. It's all consistent. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? No. We heard nothing of that. Nothing. Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? No. We heard nothing of that. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Not really, no. They weren't handed a deposition transcript and said, didn't you say this a couple of years ago? Absolutely not. Absolutely not. So when you're viewing the state's evidence, use these rules. When you're thinking about the state's witnesses, use these rules. Importantly, as we heard, as I talked about, as we have all talked about, my burden in this case, I have to prove this case to you. It is my job and my job alone to prove this case. My burden is a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. That is my burden. Just like we talked about in jury selection. If it's wet outside and we heard thunder and it's wet for miles and miles and miles, it is reasonable to believe that it rained. It is not reasonable. We have to imagine, speculate, force ourselves. Pretend that a fire truck came and sprayed it for miles and miles and miles. That doesn't happen. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict of the evidence, or lack thereof evidence. And that's a really important point. And we'll talk about that in a little bit. Now, as the judge read, as you have in your hand, second-degree murder, and we talked about this in a little bit during jury selection. What do I actually have to prove? What are the elements of second-degree murder? Number one, Pedro Jimenez is dead. Number two, the death was caused by the criminal act of Daisy Link. And number three, there was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a deprived mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous and demonstrating a deprived mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or evil intent, and is of such a nature that the act itself indicates an indifference to human life. And importantly, I do not have to prove intent that she wanted to kill him that night. If it meets those three elements in order to convict of a second-degree murder, it is not necessary for the state to prove the defendant had the intent to cause death. Merely these three elements. So let's talk about these three elements and how the state proved beyond a reasonable doubt these three elements. The first, as you heard, ladies and gentlemen of the jury, there is a stipulation in this case. Pedro Jimenez is dead. There is no disagreement there. And you must take that as true. So, the state has proven, beyond a reasonable doubt, the first of them. We're a third of the way there already. 2 and 3, the death was caused by the criminal act of Daisy Link, and there was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a deprived mind without regard for human life. I'm going to take these two together. I think it's important to talk about these two together. And importantly, we should talk about the timeline in this case. There was a lot of testimony about what the timeline is, when they found a gun, when they didn't find a gun, when Daisy admitted to the crime. The timeline is really important. June 25th at 3:06 a.m., a Ring video starts recording. At 3:11, a gunshot is heard. Daisy tells Pedro, "It's not like I hit a major artery, you'll be fine." A couple beats. "You sure you don't want to go to a hospital?" "No, okay." No fear, no adrenaline like she testified to, nothing. Calm as a cucumber. Pay attention closely to the right-hand side. You actually see Pedro fleeing. Adrenaline? Fear? Nothing. Cavalier attitude. Anger, hatred. Pissed off as hell. Not adrenaline, calm. And what's important about this too, ladies and gentlemen of the jury, I want to take a moment and discuss Pedro's statement before she shoots. Do it, do it. I want to die. I give you everything. That is a man who is broken by his wife of 9 years. It is not him charging at her. It is not him screaming at her. This isn't an assisted suicide. This is, you're pointing a gun at me. Nobody says, do it, I want to die, while there's a gun below you, hanging off the side. This is a man who has a gun in his face, steps away from this defendant. Do it then, do it! I want to die! I gave you everything. You broke my heart. You just told me you're cheating on me. This is a toxic relationship with domestic violence going back and forth. And you know what Miss Link did? She lit a match and lit that fire that night because she wanted this relationship to be over, and this was the best way to do it. This was a broken man. Maybe a drug addict, never home, not really seeing his kids all that much. A broken man. He just found out that his wife was confirming his suspicions the entire time. 3:21, 10 minutes pass. Daisy Link calls 911 and lies about who he is, who she is, and everything else.
Today, June 25, 2022, 03:21 and 57 seconds.
My name is Nancy Fire. What is the working thing?
Hi. Yeah, I don't know, I can hear a guy screaming in the house and there's blood everywhere.
Okay, down on my way. I can track your phone to see where you are.
Okay.
Do you know what happened to him?
I have no idea. He's bleeding everywhere.
Is he awake and breathing? And looks like you're at 1300. 185 down on my way.
Where?
Are you in Homestead now?
Yes, I know that.
No, I'm not okay. What is the phone number you're calling from?
76 562 9539.
7656295939. So then you get Homestead Police on the line as well. Fire is already in route.
Lie after lie after lie after lie after lie. 3:27, 6 minutes. 6 minutes after she calls 911, Officer Nicholson arrives first on scene, and she lies to him. And what does she say to Pedro, despite knowing exactly what happened?
Pedro, what the fuck happened?
Pedro, what the fuck happened? She knows. She shot him. She pointed the gun at him and discharged it as he ran away. What the fuck happened, Pedro? I shot you is what the fuck happened.
I'm in the alleyway.
Officer Nicholson asks, Pedro, what happened? And she says, if you listen closely, I hit a major artery. Listen to it carefully. This is his body-worn camera. She says, I hit a major artery. That's an admission, ladies and gentlemen of the jury. She shot and fired. And it links up directly to her statement earlier, where she mocked him. It's not like I hit a major artery. She knew what she was doing. She was aiming that gun on purpose. This is not a ricochet. It didn't hit the ground, bounce up. She shot it at him as he fled. And we actually see Pedro Jimenez's last breaths ever. We watch him.
Where's that? What's that?
They're coming.
His last moments on earth. His wife pretends she didn't know that she murdered him. The victim pronounced deceased at 3:40 a.m. Officer Rodriguez speaks to the defendant, who again lies to him. He left in a van. I don't know who his friends are, despite going there earlier in the day and picking him up. The van that officers wasted precious time searching for. She sent them on a wild goose chase. Later on, homicide detectives arrive. 5:40. 6:30. Daisy's sister shows up and says, well, if he's dead, Daisy did it. She knew. She knew. Because she knew that it was a toxic relationship. She knew that Daisy hit Pedro and Pedro hit Daisy. That Daisy was going to light a match eventually. She knew. Between 6:50 and 8:30, detective crews canvasses the scene of Pedro's murder. They walk the scene, they take photographs, they try to figure out piece by piece what's going on. They don't find a gun. At 9:20 a.m. is when the defendant enters the interview room. And watch how aggressive she is.
All right, then you can your friend that you're taking pictures. That's your sister gave me for you. She gave me some shorts and a jacket.
I'm not putting that shit.
Well,
Covered
we're
in
gonna
blood.
take that closer. You're gonna
Angry.
You want to keep clothes on the blood? Okay, we're gonna take off the shirt. And then you can put this jacket on. If there's no blood on the shorts, then I gotta see, but I don't want you to eat blood. Can we stand over there so I can take the pictures, please?
I'm not putting that shit on. She even goes on to say, at 3:52, in that hour-and-a-half video that you have in evidence, why are you treating me like I did this? Why are you taking pictures of me like I did it to him? She says at 4:08, the bruises are from a car accident, which she confirmed, by the way, on the stand when I was cross-examining her yesterday. She says the bruises don't apply to this, trying to make it seem like he would hit me. Lie after lie after lie after lie. At 12:27, canines locate a firearm. I'm sorry. At 12:27, a residential search warrant is executed for Daisy and Pedro's home. And what do they find, ladies and gentlemen? Look closely. Men's shoes, men's clothing, adult men's clothing. Pedro lived there. It was his home. Same time, canines locate a hidden firearm. Hidden firearm. That was about the only honest thing she said that night, that she hid that gun. And it was her gun. And it's not until 3:39 and 4:20 that the defendant begins her interview. And we know that, not just because we heard it and we can see it on video, but the time of when she waived her Miranda rights and chose to speak to officers is actually memorialized on that Miranda form itself. Do it. You have the right to remain silent. You don't have to talk to me if you do not wish to. You don't have to answer any of my questions. Do you understand that right? Yes. Should you talk to me, anything which you say may be introduced into evidence against you. Do you understand? Yes. If you want a lawyer to be present during questioning at this time or any time hereafter, you are entitled to have a lawyer present. Do you understand this? Yes. If you cannot afford to pay for a lawyer, one will be provided for you at no cost if you want one. Do you understand that right? Yes. And then she waives. She voluntarily spoke to them. And she says a lot of very interesting things during this statement. But I think what's most interesting here is her demeanor during this. She's crying, she's sad, she's scared, until she's confronted with one of her lies. And you can actually see her demeanor change.
Wait, what if I tell you that you're lying right now? Say your bullshit.
She's not scared anymore. She's mad. You see her demeanor change when officers catch her in a lie. What if I have you on video saying, it's not like I hit a major artery, you'll be fine? Her change in demeanor is important here. What else does she tell us?
Yeah, I was angry.
I was angry. It doesn't say I was scared. I'm not talking about something that happened 5 days ago. I was angry. What does she say about the shooting? One of the 5 different stories she tells that night, and yesterday as well.
Just in my hand. Okay, he was down, and then once he said, oh, you're gonna sleep outside tonight, Rich, that's when I literally just lifted it up and I just cocked it, and I shot it. It was already cocked and everything. I shot it.
You catch that? It was already cocked. He says, you're sleeping outside. I lifted it and I shot. It was already cocked. She was outside, not scared. Her with the deadly weapon. We know Pedro never had the gun. We know he never had a weapon. She said as much. At 5:03 is when she tells officers where the firearm is. 5 hours prior, though, K-9 already had located it. She wasn't being helpful. They already found it. They were already piecing the picture together. As she's being interviewed, they're doing their work. They find this ring camera footage. They find the firearm. They're doing their job. They're watching video. The defendant is eventually arrested that day, and then on June 26, a secondary canvass is conducted with other K-9 officers. And they don't find anything. They don't find the casing that Daisy Link hid, because she didn't want to get caught. We also know, based off the subsequent search, Pedro's is packed that night. Well, let's talk about this. We heard not from 1, not from 2, not from 3, but 4 officers about that video footage at Robert Cisneros' house. We heard from Robert Cisnero himself. It's an older model DVR. It's plugged in, it's hardwired. I saw it with my own eyes. I saw the victim running, hiding behind bushes, running and then collapsing. A woman passing by, going to his body, manipulating his body, walking away, coming back. We actually can piece together his path based off the evidence. The CSI photos, the blood spatter. We know that Daisy's house is where he got shot. I'm sorry, Daisy's house. This is the porch. And what's important is those two doors. She says that he was charging at her while she was on the porch. I don't know where, I don't know how, but that's what she tells us. And after he gets shot, he runs this way. And we know that from the blood spatter. And Daisy walks this way. You'll be fine. Not like I hit a major artery. You'll be fine. And he continues running. And we actually see that in that same video. And blood spatter continues. And we know, again, that he travels up through the alley until he gets to this car. Blood spatter again, before collapsing and dying. Right here. And look at where the Chevy Trax is. Look how far away it is. Daisy would have had to have walked feet after feet after feet to get to him and hide his stuff back in the car. It took her time. It was deliberate action she was taking because she didn't want to get caught. And we can also piece together Daisy's path that night as well. This is their home. She shoots and fires as he's running away from her. And she goes this way, by the trampoline. She says, not like I hit a major artery, you'll be fine. Beat, 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 beat. You sure you don't want to go to the hospital? You'll be fine, okay. And then she comes back and she hides the firearm, her firearm. She has to come back, get in her car, and drive. And she waits. She doesn't call 911. It was just a gunshot. She knows she hit him. She doesn't think she hit him where she hit him, but she knows she hit him. And so she goes to look for her husband of 9 years. She's not afraid of him. She's not scared of him. She's not thinking about an incident that occurred 5 days prior. This is a toxic relationship, and she just lit the fuse. I cheated on you, you're right. You're never home. And so she says, my husband of 9 years, I just shot, let me go find him. So you can't take back a murder. Her rendering aid, attempting to render aid, lying to officers. Lying to officers is relevant. Rendering aid is irrelevant. You can't take back a murder. And she goes this way and up and back. We know she doesn't go this way, there's a car blocking it. We know it's not this way because her car ends up over here. And it's important, she goes this way, up, and she walks over to Pedro's body, turns her car off, and takes his items out of his pocket. His phone, his money, his keys. She goes back, and then starts rendering aid. It took her time. These are deliberate steps that she took. The shot itself. He was running away. It went through his foot, out through his ankle, and then through his thigh. In, out, in, out. It was a clean shot. It was a good shot. The only way that shot makes sense with one shot, from what we heard from Dr. Mathis, is when somebody is running away. That's the trajectory that it took. That is the only way that that is possible. And if it missed the foot, it's still going through the thigh either way. It's still hitting that artery either way. This didn't bounce off the floor through his foot, ricocheting, and then ending up in her thigh, or his thigh. It was a good shot. Again, we can see Dr. Mathis's work. Entry, exit, entry, exit, through the femoral artery. And how do we know that it was Daisy's gun? Pay attention. Pay very close attention. Earlier in the day, minutes after the shot, what's in her hand? The firearm she hid. She got that gun. It was her gun. And how do we know it's her gun? Well, we heard from criminalists from the Miami-Dade Crime Lab that they tested it for DNA. And the majority of that DNA belonged to none other than the defendant, Daisy Link. And how do we know that? The statistic they came up with. 1 in 28.71 septillion that it is her DNA. Septillion, that's 24 zeros. That's not a small number. The population of Earth is 8 billion. That's 24 zeros. It's her gun. Let's talk about reasonable doubt again. And this is so important because I'm about to talk about the defense witnesses. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. A reasonable doubt as to the guilt of the evidence of the defendant may arise from the evidence, conflicts of evidence, or lack thereof. And so what's important here, ladies and gentlemen of the jury, there's actually no reasonable doubt for the state's evidence. But when you look at conflicts of the evidence, you should also take a look at the evidence that the defense presented. And to be clear, they don't have to do a single thing. Her attorney never has to open his mouth. I'm the only one that has to do anything. But they gave us interesting evidence, interesting testimony. And you should weigh that evidence, that testimony, the same way you weigh the state's evidence. Did the witness seem to have an opportunity to see and know the things about which the witness testified to? Absolutely not. Absolutely not. We heard from her niece, Laylin, who lives in Texas, who flew to Florida 4 days prior. And what did she do? Well, I went to my aunt Crystal's house and we hung out, and then there was a barbecue a couple days later, and I saw some injuries to Daisy, but I can't tell you where those injuries are from. I don't know what day it was taken. I wasn't there the night that he was killed. I wasn't there when he got shot. She wasn't there. We heard from Crystal, same thing. Same thing. And she even admitted she didn't know if Pedro lived there or not. Crystal pretended like she knew. Laylin pretended like she knew, but she was challenged on it. You're not coming in to Florida often. You live in Texas, you don't know. It's entirely reasonable to believe that when Pedro comes home, your aunt's not telling you, hey, my husband's home. She has no idea. Her mother testified as well. She left. They said it was such a dangerous situation, she left her grandchildren with such a dangerous man. She watched her daughter get choked, nearly murdered in front of her, and she leaves? It's one thing to say, I can't control this 30-year-old person. If they want to do what they want to do, they're going to do it. It's an entirely different thing, though, to leave an 8-year-old and a 5-year-old in that situation. Because it didn't happen. Did the witness seem to have an accurate memory? No. Crystal denied making a statement to Detective Morales, but then challenged. She goes, well, actually, I don't remember. They're confrontational. I think Crystal even said, how would I know? I'm not a psychic. Did the witness seem honest and straightforward in answering the questions? Absolutely not. Same thing. Crystal said, I'm not a psychic. How would I know? Well, it's your sister, right? Shouldn't you know about her abusive husband? You know about the toxic relationship. You know she hits him and he hits her. But you're not a psychic. You can't put one and one together. You know your sister has a gun. I just showed you it's her gun. Did the witness have some interest in how the case should be decided? Does the witness testimony agree with the other testimony and other evidence in this case? Has the witness been offered or received any money for fear of treatment or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Let's talk about Pedro Jr. for a second, and his testimony being so critical. What did he tell us? I'm here to get my mom out of jail. I'm here to get my mom out of jail. I live with my grandma. I talk to her once a week at least about this case. I make mistakes. I forget sometimes. And what happens? Grandma corrects me. Sometimes I say, Daddy shot twice 5 days before. But no, Grandma, who wasn't there, mind you, corrects me. If they're willing to coach a child on what to say, it is very reasonable to believe that they have been coordinating their testimony too. They weren't there, they don't know, and a child has admitted. Children are pretty honest. And honestly, Pedro Jr. seems like a great kid, really honest. And said, when I make a mistake about the night that my grandma wasn't there, she tells me what happened. She wasn't there. How does she know? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Absolutely. How many times did they get impeached with their own depositions? Let's talk about the lease agreement. Now this is an older one, and I want to bring to your attention 3 major things here. Tenant's email address, pete89.pj@gmail.com. 2 phone numbers. Top right, my copy. My copy, not original, not a stamp, not a filed one, my copy. And then right here, where it says Daisy Link, pay very close attention to this line. What does that look like? That looks like whiteout. My copy. And if you make it out, you can actually kind of see Pedro Jimenez's name right underneath it. But that's consistent with being whited out on her copy, not the original, her copy. Let's talk about the newest lease as well, Defense Exhibit D. Well, ladies and gentlemen of the jury, Pedro's name's not on here. But you know what's also not on here? Any signatures? How do we know this wasn't updated? There's no initialing, there is no signatures, no dates and times. How do we know? Let's talk about earlier in the night. They say that this was such a toxic family, such an evil man. Oh, I'm sorry, actually, let me back up. Daisy said he was a good guy. That's what she said, he was a good guy. Not the family, though. They came to rescue her, but they waited 4 days. They were there, they were having a barbecue. They flew in the middle of the night. They left their grandchildren at home, watching that. Earlier in that day, after Daisy picked Pedro up, on her own volition, mind you, Pedro holding a beer. Who shows up? His children, her children, their family. They are a family. No fear, not being scared, they are a family. Even later, the victim returns to the car. Probably left some stuff in it. After all, he rented that vehicle. And then, importantly, who walks back to the apartment? Pedro and Daisy. I showed you this just a few minutes ago, but pay attention to what's in Daisy's hand. Gun. That same gun. Her gun. Daisy told us an interesting lie yesterday, and her mother did too. That was completely refuted by actual evidence. They said that Pedro punched through a wall and opened this door. Well, good thing we have photographs. Tell me where the broken window is. Even if he punched through that, look, I'm not the biggest guy in the world. I don't believe in superheroes. I don't think Pedro is Mr. Elastic. He can't open that door from there. There's no broken window. There's no punch window. That didn't happen either. Lie after lie after lie after lie. Another really important thing. Let's talk about what happened 5 days prior. I believe something happened. Hell, we have pictures. I absolutely believe something happened. But not what Daisy said. Not what Pedro Jr., who was coached on what to say. How do we know that? Well, Daisy actually told us. She has cameras. They record things. That would have happened on or about the 20th or 21st. And what's really interesting here is the conveniences. It is really convenient. We have the 18th. We have the 22nd. And then the night of the murder. This is from her phone. Isn't it convenient how that video doesn't exist? Isn't it convenient? What actually happened that night, ladies and gentlemen of the jury? What actually happened that night?
I was mad as fuck.
That's what happened. She was mad as fuck. Pedro's never home. He's on the road all the time. He's off getting high. I was mad as fuck. Ladies and gentlemen of the jury, the state has proven beyond a reasonable doubt the death was caused by the criminal act of Daisy Link. She pointed the gun. It was already pointed at him when he made those statements. And he fled and he ran and she fired. She actually made a very surprising admission yesterday when she said that she didn't think she was going to hit him. She pointed and fired with purpose. She said yesterday, it was contradicted by her own statement, which is full of its own contradictions over and over and over again. I didn't think I was going to hit him. Say it's proven beyond a reasonable doubt, element 2. Element 3, there was an unlawful killing of Pedro Jimenez by an act imminently dangerous to another and demonstrating a deprived mind without regard for human life. Pointing a firearm and shooting it is imminently dangerous. Deprived mind, I don't know what's more deprived than after you shot someone, mocking them. You'll be fine. Not like I hit a major artery, you'll be fine. After breaking this man's heart and lighting that fuse. Let's talk about lesser included offenses. Well, let me back up. After the state has proven element 1, element 2, and element 3, the state has proven beyond a reasonable doubt that the defendant is guilty of second-degree murder. As you heard, there are lesser included offenses in this case. Lesser included offenses are offenses that make up the actual charge, but they're smaller. There's less there. And as you heard, in this case, it's manslaughter. What do we have to prove for manslaughter? That Pedro Jimenez is dead. That, we all agree on. You have to take that as true. We all agree. And 2, Daisy Link intentionally committed an act or acts that caused the death of Pedro Jimenez. She lifted the gun, she pulled the trigger, as he ran. That is an act and cause the death. We heard Dr. Mathis say, cause of death, manner of death, homicide, gunshot wound. Daisy Link did that. I've already proven to you, beyond a reasonable doubt, that this is a second-degree murder. But I've also proven manslaughter as well. Aggravation of a felony by carrying a firearm. This is important too because you will have a verdict form that you will have to make certain decisions on. If I've proven my case, you must make the determination beyond a reasonable doubt that Daisy Link actually possessed the firearm during the commission of the crime. She's admitted that. Whether the state has proven beyond a reasonable doubt that Daisy Link discharged the firearm, she's admitted that. Whether the state has proven beyond a reasonable doubt that Daisy Link discharged the firearm and doing so caused death or great bodily harm to Pedro Jimenez. He's dead. Proven that. This is really important too, justifiable use of deadly force. Self-defense, that's what this case is. That's the defense that they have put on. The defendant was justified in using deadly force if she reasonably believed that such force was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of a burglary to a dwelling or false imprisonment against herself. I'm not going to talk about those because there's no evidence of those. But let's talk about imminent for a second. I had a conversation with Mr. Cruz during jury selection. I threatened him, remember? We were at Publix in the line. I cut him, he said some words to me. I said, I'll see you outside. I lifted my shirt, I showed him my gun. Imminent, it is happening right there, right then. Not 5 days before, not hours before, right then, right there. There was a lawyer on the panel who mentioned a bus 200, 300, 400, whatever it was, feet away. And he said, that is imminent. No, it's not, because there can be an intervening cause. Car accident. Imminent. Right away. So as the judge showed you, your verdict form will look a little like this. I couldn't fit in the signature line for the foreperson in the date of crime, but this is what you'll get. This is something you'll get. And you're going to have to make a decision here. Guilty of second-degree murder, guilty of manslaughter, or not guilty. Well, again, I've proven my case beyond a reasonable doubt. So you check off second-degree murder. And as we talked about already with the aggravation of a firearm, she did actually possess a firearm. She did discharge a firearm, and she did cause death. That's what your verdict form will look like, ladies and gentlemen of the jury, because there is only one verdict in this case that is consistent with the evidence, consistent with the facts of this case. And the only verdict that justice demands, and that's this defendant, Daisy Link, is guilty of second-degree murder. Thank you.
Thank you. And now for the defense?
Can we take a quick comfort break to start this up?
Sure. Why don't we do this? Why don't we go to the jury room for a few minutes and we'll come back out and then we'll do the other closing.
All right, the jurors, watch you step down. This jury room is different.
Mary's, did you give them the time that was used up? Did you tell the state how much time they used up? 50 what? 53, thanks. So we have 7 minutes, so we used up 53 minutes? Okay, that's fine, you're keeping time. All right, folks, we'll be back in a few minutes. Who off record? Did you figure out who ordered the chicken? assigned jurors are counted present for. We can be seated. Everyone can be seated. Defense lawyers, state, defendant are present. Alrighty, folks. As I had before we go into Mr. Tomas's closing, page 9 of your instructions, we need to swap it out. There was a typo that I read the correct wording into the record, but because we're allowing you to take your own copies back with you, and I just want, so take out page 9, give it to Lisette. If you need a staple, I know this is getting very technical. If you need a staple or paper clip, let us know. All right, Lisette, here's. Lisette, see if they want a staple. You can give them paper clips too. No? We have paper clips up here too. Okay, so it looks like who has not swapped out page 9? All right. Everyone swapped out page 9. Thank you all for your continued attention. Now the defense will have an opportunity to give their closing argument.
And that presumption is to stay with you throughout this trial until you go back there and deliberate. When you're back there deliberating, if you decide that the state has proven their case beyond all reasonable doubt, then that's another story. But she doesn't lose that presumption until you reach that decision, if you reach that decision. If you remember, because it's been weeks already, but during jury selection, there was a juror sitting in the back, in the corner, and we were talking about that example that I gave about the cat and the mouse and the hole in the box. You all remember that? Okay. There was this one juror, he was sitting in the back, and he said, I can't make a decision because I don't have enough information. Well, as I explained to him, the cat is presumed innocent. You're not convinced that the cat's guilty, right? No, I haven't been convinced. Okay, well then, your decision is not guilty. He's presumed innocent, so your verdict, right? Your verdict is not guilty. If that changes, if you're convinced otherwise, then you change it. But if you're not, the verdict is not guilty. It's pretty simple. I would submit to you that right now, before I say another word, every single one of you should vote not guilty. I'll explain in a moment, but you should, because the state has not overcome the reasonable doubt in this case. Now remember, I will remind you, I don't have to prove that Ms. Link was justified in pulling the trigger. They have to prove that she was not justified, and they haven't. Now, I want to talk a little bit about some of the things that the state said a moment ago. They said a lot. They said that Daisy was upset because Pedro wasn't home. There's no evidence of that. They just made that up. There is no evidence of that whatsoever. Whatsoever. Point to one witness, one piece of evidence that establishes that. You won't find it because it hasn't been introduced. It's their burden to prove it. They want to say something, they want to allege something, they have to prove it. They can't just get up here, say it, and say, oh, you got to believe us because we're the state. Believe everything we say, believe nothing that the defense say. We're the good guys. It doesn't work that way. They have to prove it. Daisy's mother flew in for a barbecue? That's what he said. You know that's not true. And they didn't even have that barbecue. And yes, they were going to have a barbecue the next day. You heard why. Number one, because she lives in Texas and she has other family that she doesn't get to see, so she's going to see them. And number two, they don't want to make it obvious that Daisy's leaving because they don't want Pedro to flip, which he did anyways. But they don't want him to flip, so they're doing it in a way that he won't find out. That was the testimony. Have they rebuffed that testimony? Have they proven that it's not true? No, they haven't. The most that they've done is, well, maybe it's true, maybe it wasn't. Have they disproven it? They have not. Can you point to a single piece of evidence, to testimony, to anything that rebuffs that? You cannot, because it doesn't exist. The state mentioned about phone calls between Pedro and Daisy. Pedro didn't have a phone because he tossed it after he almost beat Daisy to death a few days before. And then he had to get another phone, and you heard testimony about that. You heard testimony about that. When he went to his friend Kevin's house to do all that coke and to buy all that cocaine so he could have a party while he's driving a big rig across the state, snorting cocaine, he didn't have a phone. He didn't have a phone because he tossed the phone after he almost killed Daisy a few days before because he didn't want the police to track him.
Objection, background evidence.
Overruled.
It wasn't evidence. She testified to it. I'm not making it up. I'm telling you what was in evidence. You can use your own recollection about what you heard, but we all know that that came out in evidence. I'm not making it up. The state has repeatedly said that was their home. No, it wasn't. They can't just say it and say, there, we proved it. They haven't proved it. This thing is really blurry. But for future reference, this is Defense Exhibit A. It is 3 pages long. Pedro Jimenez had 2 driver's licenses. These driver licenses, both of them, can't see it here, but you can see it yourself when you go through the evidence, both of them have his mother's address. You have seen lease agreements where he is not on the lease document. You have heard testimony from multiple people, including his son, that said he didn't live there. But most important, this is Exhibit F, Defense Exhibit F. This thing's horrible. You can look at it when you're deliberating. This is a court order. A court order. Now, the judge read the instructions, and I'm going to tell you exactly what the instruction that she read to you says. And I am talking about page 11 of the instructions, which you will all have with you in the back. Parental rights. The court has taken judicial notice that there are no court records in Miami-Dade terminating the parental rights of Pedro Jimenez. That is right. During my opening statement, I told you he lost his parental rights. I didn't say terminated, I said lost. When your parental rights are terminated, that means it's terminated. That means there's no coming back. They're gone. When you lose your parental rights, you can get it back. And this order provides a pathway for Pedro Jimenez to get his rights back. You know what that pathway is? First page, bottom. Substance abuse assessment, individual therapy. parenting therapy, domestic violence. Domestic violence. September 20th, 2019. Ever since September 20th, 2019, that man was limited to seeing his children by court order 1 time a month under the supervision of his mother, who you've heard doesn't even live in this state. And you've heard no evidence or any indication that she ever came back, because she didn't. And he gets to have FaceTime calls with the children at the sole discretion of the mother. The sole discretion of the mother. Do you think courts and judges limit a parent's ability to see their children flippantly and for no reason? They did it because Pedro Jimenez was a drug addict, a cocaine abuser, an alcohol abuser, and a wife-girlfriend abuser. And, as you've heard throughout the course of this trial, he was doing nothing to get those rights back. He was doing the opposite. He was on his way to losing them permanently. Why? Because 5 days before he died, he beat Daisy Link halfway to death. Beat her halfway to death. Smashed her skull in. Did it in front of his 7-year-old son. Did it in front of his 5-year-old daughter. Did it in front of 4 other kids. 4 other kids who were present. The state got up here and told you Pedro was not dangerous? Are you kidding me? Is that not the very definition of a dangerous man? He proved what he's capable of just 5 days before this happened. The state said a lot of things during their closing. I didn't agree with any of it except for 2 things. One thing that they acknowledged, Pedro was not a good guy. I agree. No, he wasn't a good guy. No, he was a cokehead, wife-beating lunatic. That's what he was. He terrorized and traumatized Daisy Link. He terrorized and traumatized his own children, and he terrorized and traumatized other children. This is a man that was capable of beating a woman halfway to death in front of children, in front of his own children. That's dangerous. Whether Daisy acted afraid of it or not doesn't change what he did. Whether Daisy made a flippant remark or made fun of him or insulted him doesn't change what he did. The state wants you to ignore and forget that he did that. Well, they can ask you to forget whatever, but you know what happened. This order Paragraph 3 of this order, Exhibit F, the minor children, Pedro Jimenez and Mia Jimenez, shall remain in the legal and physical custody of the mother, whose name is Daisy Link. Next paragraph, the non-custodial parent of Pedro Jimenez and Mia Jimenez is Pedro Jimenez. And then further down, Pedro Jimenez has not substantially complied with his case plan. A brief description of this plan is as follows: substance abuse treatment, assessment, individual therapy, parenting, domestic violence. He didn't do it then. He wasn't going to do it in 2022. And quite frankly, it's clear that he was never going to do it. He was less concerned with getting back his kids and having more time with his kids. He was more concerned with getting high and beating up Daisy Link. State will tell you that Pedro was broken, that Daisy did all these horrible things to you. They completely ignore what he did to her. And you can't ignore that because that goes to her state of mind. That goes to her state of mind right when she pulled the trigger. Yes, she went to pick him up, and I'll submit to you, that was a bad choice on her part. But you know what? Relationships are complicated. When two people love each other, even if it changes, it's complicated. When you add children to the mix, it's complicated. When you add property to the mix, it gets more complicated. When you add the fact that these kids, even though their dad's not a good guy, they love their dad. She knows that. So yes, she doesn't want to get him arrested. She doesn't want to get him deported. She doesn't want to do that. She just doesn't want to be with him anymore, and that's her right. And why would she want to be with him? He beats her up. He did so for almost the entire course of their relationship. And you need look no further than this order to know that. The state went on to say that Daisy Link picked up the casing, the spent casing in this case. There's no evidence of that, ladies and gentlemen. None whatsoever. They can say it till they're blue in the face. They have to prove it. It's their burden. And if they haven't proved it, which they haven't, then you can't accept it because it hasn't been proven. There's no evidence that she picked up any casing whatsoever. She was with police for almost an entire day from the point they got there at 3-something in the morning till she got to the station several hours later, till she started her 11-hour-long interrogation at what, 9? So she was done, what, the following evening? That's almost 24 hours. They had eyes on her the whole time. But they want you to believe that she found this casing and she got rid of it. Well, that doesn't jive with the evidence. There's no evidence of it. She told them where the gun was. She called 911. She tried to help this man as soon as she found him. And the only reason she didn't call 911 sooner is because Pedro stole her phone. The state said that the officers were kind to her. Are you kidding me? No, they weren't. They say that she threw a chair at Detective Morales. No, she didn't. There's no evidence of that. None whatsoever. There's 100 officers on there. All of them have body cams. Have you seen a single body cam of her throwing a chair at anybody? No, because she didn't. The state talked about Pedro Jr. They said one thing, and this is the other thing that I would agree with, that Pedro Jr. is a very smart boy. I agree, he is a very smart boy. Kids are honest. Yes, they are honest. And I would submit to you, Pedro Jr. was honest in his testimony. I specifically asked him, and he specifically said, I'm not telling you, nobody told me what to say. This is what I remember. Has he spoken to his grandmother in the last 3 years? Yes, because he lives with her. What's he supposed to do? What's he supposed to do? Because he speaks to his grandmother, therefore you shouldn't believe a word he says? You can judge that boy's credibility on your own. We have footage in this case which was deleted. It was lost while it was in police custody. The police only viewed one snippet, which is when Daisy Link went to Pedro while he was lying there. They didn't bother to look at anything else. They didn't bother to look at any other footage when he stole her purse or when he was running back and forth 3, 4, 5 times that he was running back and forth, that Daisy's mother told him to leave, that Daisy told him to leave, or they threatened to call the police. There's none of that. It would have been on there, but they lost it. Nobody knows how. Everybody's saying, it wasn't me, I don't know, we did everything. It must have been the machine. It wasn't the machine. They gave the machine back to the owner, it worked fine. The only difference is a month's worth of footage is gone. I didn't delete it. The police did. The police lost it, the police destroyed it. What does that mean? They have it in their control and they lose it. That is incompetence of the highest order. This is a murder case. That is incompetence, ladies and gentlemen. You should consider that. We have a blood trail here, which begins in front of the house. The state will have you believe that at the time Pedro was shot, he was running away. He wasn't running away. He was running to the house. He was going to barricade himself inside that house where those kids were. He was going to keep her out, and he was going to do God knows what. I say God knows what because we already know what he did 5 days before. We already know that he snorted about a mountain of cocaine shortly before this happened. That was her home, which she has a right to defend. Pedro did not have an invitation or a right to be in that home. He made it clear that he was going to break into that home and lock her out and keep her away from her children, which he had no right to do. And importantly, she has every right to use deadly force to prevent him from doing that. And this is not just me talking, this is the law. This is the law, which I'm going to read to you in a moment. The law, I will remind you, that each and every one of you swore an oath to follow. Was Daisy honest with the police from the get-go? No, she wasn't. Okay? No, she wasn't. Should she have been? Probably. But can someone really understand what's going through somebody's mind when they're in that position? I think we can all agree that what happened to Daisy Link in the 5 days leading up to this incident was extraordinarily traumatic. Unless you've been through it, it's hard to imagine what that's like. I would say it's almost impossible to imagine what that's like unless you've actually experienced it. It's very easy to second guess and judge somebody for their actions when you don't know what was in their mind at the time they made it, ladies and gentlemen. As I told you before, relationships are complicated. How many times, how common is it to see a couple who clearly are wrong for each other, who clearly shouldn't be together, but for whatever reason they keep coming back to each other. They keep interacting. Maybe they separate, maybe they come back, maybe they go back. It happens. Well, that's because these things are complicated. There are children involved. There's a history involved. There's a familiarity involved. And yes, there's love involved. And that makes it very difficult. So it's very easy for us to say, you should have left. You shouldn't have called them back. You shouldn't have gone to Again, this is a court order. This court order says Pedro gets to see those kids once in person, see them in person, once a month with the supervision of his mother. Daisy had a fear, a reasonable fear, that if the court found out that she was allowing Pedro to see those kids in person, knowing that he's still being violent, knowing that he's still abusing drugs, A court could very easily and theoretically say, you know what, you're not supposed to have him around those kids, you know what he's doing, we're gonna take those kids away from you. As a parent, is there anything scarier? Anything scarier than losing your kids? I don't think so. If you can think something, I'd love to hear it. I can't think of anything. I'd rather be killed than lose my kids, personally. She feels the same way. That's why she did what she did. You can disagree with it. You can not like it. That's fine. That's your right. But that doesn't change the fact that at the time she pulled the trigger, she had every right to do so. This paper that you all have, jury instructions, this is the only law that applies in this case. There is no other law, no other instructions that apply to this case. You are to decide your verdict based on these instructions and these instructions alone. Okay? So let's go through the instructions. Page 3. This is a really loud one. I'm sorry, I can't have it. It's the best I can do, I'm sorry. Page 3. You all have it, so that helps. Justifiable homicide. Use of deadly force is justifiable if done while resisting an attempt to murder or commit a felony upon the defendant, in or upon any dwelling house which the defendant was at the time of the killing. Miss Link was at her home. She had every right to be there. Mr. Jimenez had no right to be there. I don't care if his kids were there. He had no right to be there. He had no right to see them. You saw the order. He did not live there. He did not have the keys. He was not on the lease. The address was not on his license. You've heard testimony from multiple people that he did not live there. You have not heard testimony from a single witness that said he lives there. They want you to believe he lives there because it's convenient for the case. They don't want you to believe that he didn't live there, which he didn't, because they know that if you know he didn't live there, they're done. Their case is over, and I'll explain that to you in a second. So the question is, has the state proven to you beyond a reasonable doubt that Pedro Jimenez lived in that house? No, they haven't. At best, maybe you can all say, yeah, I'm not sure. Maybe he did, maybe he didn't. What are they pointing to prove that he lived there? Because there are some shoes and some shirts that appear to be for males in the house? Does that prove he lived there? I'm sorry, it doesn't. And use your common sense, people, okay? I still have stuff at my old house, and I've been divorced for 10 years. It's still there. It's not my house. I don't live there. I don't have a key. I can't go there and come and go as I please. No, I have to knock on the door. I have to be allowed inside like everybody else. Was that my house before? Sure. It's not anymore. Do I still pay the mortgage? Yeah, I do, actually. But I still don't have a right to go in there because it's not my house anymore. That was not Pedro's house. And unless they prove that it was his house and that he lived there beyond a reasonable doubt, then no. And as far as you're concerned, that was not his house. He didn't live there. He did not have a right to be there. Same page, page 3. Excusable homicide. The killing of a human being is excusable and therefore lawful. The killing is lawful, which means it's not illegal, it is lawful, not a crime. Under any one of these following circumstances, when the killing is committed by accident or misfortune, in doing any lawful act by any lawful means in the ordinary caution. Okay? Number 2, when the killing occurs by accident and misfortune in the heat of passion, upon sudden and specific provocation. Can you see how that scenario could apply to this case? He's been asked to leave multiple times. You heard testimony. To the ground. She's already told him to leave. She grabbed the gun. She told him, leave. And you heard what he said. I'm not leaving. I want to die. I'm ready to die. And then he ran to go break into the house. Then she fired. And then, and only then, when she fired, that's when he started running away. It took the shot. It took her firing the gun for him to abandon his intention to break into her house. And if you are stopping somebody from breaking into your house, that is justifiable use of deadly force. And it was going to happen imminently. We know that. We saw the blood trail. We heard the testimony. He was going to break into her house. She did everything she could to stop him. He refused. So she fired the gun. And it worked, because when she fired the gun, he ran off to the alley. I want to talk about the instruction for second-degree murder. This is on page 4. You see it there. Three elements that the state has to prove beyond a reasonable doubt in order for you to be able to convict Daisy Lynn. And this is what your case is going to come down to. Number 2. The death was caused by the criminal act of the defendant. And number 3, there was an unlawful killing. So, I highlighted the relevant portions in 2 and 3, just to give you all a little guidance there. So, in order for you to convict her of anything, whether it's murder or manslaughter, of anything, you have to find that her firing that gun was a criminal act and that her killing Pedro was unlawful. So, in other words, what your deliberations are going to come down to is whether or not this killing was justified or not. Was Daisy justified in using deadly force or not? That's it. That's the decision you have to make, and that's going to be how you reach your verdict. Okay? It says it right there. So, let's fast forward. This is the key instruction in this case, ladies and gentlemen, page 8. It's the longest instruction out of all of them. It's, oh boy, look at that, it's 3 pages. It's 3 pages long. So, sorry, but we need to go through it. Justifiable use of deadly force. 3rd paragraph, okay? Defendant does not have the burden of proving that she was justified in using deadly force. Instead, for you to find her guilty, the state must prove beyond a reasonable doubt that she was not justified. This is what I said earlier. I don't have to prove that she was justified. It's the other way around. They have to prove she was not justified. So have they proven that she's not justified? Have they proven it beyond all reasonable doubt? Well, let's see. Let's have a look. Keep reading. The law on justifiable use of deadly force is as follows. Defendant is justified in using deadly force if she reasonably believed that such force was necessary to prevent the following: imminent death of great bodily harm to herself or another. So if she believes that imminently means it's about to happen, it's going to happen any moment now, that she's going to get hurt or another person's going to get hurt, you have the right to use deadly force in that instance. Okay? And then there's another option. Or B, the imminent commission of burglary or false imprisonment against herself or another. At the time that she shot, Pedro Jimenez was running to break into her house, to barricade her out of her house. Okay? He had no right to be there. When you enter somebody's house without permission, that's burglary. I'm going to read you the definition of burglary in a moment. So that's number one. That's one felony that he was about to commit, which, according to this instruction, if she knows that he's about to commit a burglary upon her house, she has the right to shoot him, to stop him. This is the law that you are required to follow. In addition to burglary, false imprisonment. There are 2 kids in that house. Those kids are in her custody, not in Pedro's custody, her custody. By barricading himself inside the house, Pedro would be illegally separating those kids by force from their mother, without permission, without authority, without any right to do so. She has a right to use deadly force if she has reason to believe that that's about to happen. And we all know that that was about to happen. He was about to burglarize her home, he was about to lock her out of her home and commit false imprisonment upon her kids. So, moving on to the next part. This long paragraph here, right here on page 4, on page 8, this paragraph has to do with whether or not Daisy Link had a duty to retreat or not a duty to retreat. You can go through that and read it to yourself, but ladies and gentlemen, as you will see in a moment, she had no duty to retreat because she had every right to be there because that was her home. On the other hand, Pedro Jimenez had no right to be there because that was not his home. He had been told repeatedly to leave. He had been threatened that they would call the police. And he did leave, but he kept coming back. Multiple times, he kept coming back, kept terrorizing this woman. She did it while her mother was there, and then he did it again after his mother left. His mother left at 1:32 in the morning, and he still came back after that. He's terrorizing her at 3 o'clock, 3-something in the morning. I'm going to refer you to page 8 at the bottom right here. If the defendant was in a dwelling or residence in which she had a right to be, which she did, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent death or great bodily harm to herself or another, or the imminent commission of a burglary or a false imprisonment against herself or another. So again, this says, again, if she has reason to believe, well, first of all, it says, if she's in a place where she has a right to be, there's no question. She had every right to be there. That was her home. If she's in a place where she has a right to be, she can use deadly force to stop somebody from burglarizing her home and to stop somebody from keeping her outside of the home and keeping her away from her kids who are inside the home. She had a right to use deadly force in each of those and in both of those. This is the law that you are required to follow. After this defines the crimes of burglary and false imprisonment. These are the 2 crimes that I would submit to you. The evidence has clearly demonstrated Pedro Jimenez was intent on doing and was in the process of doing, and the only reason he stopped from doing it is because she fired that shot. That was the only way that she was going to stop him from doing that, and we know that from Pedro Jimenez himself. I'm ready to die! What does that mean? I'm going to do what I want. You want to stop me? You're going to have to kill me. You're going to have to kill me. burglary, entering a dwelling owned by or in the possession of another, and at the time of entering the dwelling, the unauthorized person had the intent to commit the crime of false imprisonment. Please tell me, how has the state disproven that this was about to happen? Can you honestly say to me that the state has convinced you beyond all reasonable doubt that Pedro Jimenez was not in the process of rushing in to barricade himself inside that house and lock Daisy Lake out? Have they disproven that beyond a reasonable doubt? If the answer is no, then your verdict is not guilty. If the answer is yes, then okay, then I would ask you to ask yourself, how have they proven it? What have they shown? What have they introduced to prove that? I would submit to you they've introduced nothing to disprove that that man was going to do that. Certainly not beyond a reasonable doubt. That's burglary. False imprisonment, that's the next one. We're still on page 9, it's right here. False imprisonment is defined as follows: to forcibly or secretly confine or abduct another person without lawful authority to do so. Forcibly would apply here. He was attempting to forcibly confine those kids within that house and keep the mother out of the house. The next paragraph defines secretly. You're free to read that as much as you want, but secretly doesn't apply here, so I'm not concerned with that. The next paragraph is very important. Very important. Confinement of a child under the age of 13 is against the child's will if such confinement is without the consent of the child's parent or legal guardian. In other words, if you're locking 2 kids inside a house against the will of those kids' legal guardian, and those kids are under the age of 13, which, as you already know, those kids were ages 7 and 5 at the time, then that's false imprisonment. We know that Pedro was not their legal guardian because that's what this order says. So unless the state is going to come up here and find a way to invalidate this court order, which if they have a way to do that, I'd love to hear it. They're not going to. This is a court order, this is a valid court order, and this court order was in place in full force on that night. Daisy Lake asked him to leave. He did not respect her request to leave. He was going to commit false imprisonment. I'm going to keep reading. Please bear with me, but again, this is a long instruction, but it is the most important instruction in this case, because this is what your deliberations are going to come down to. In deciding whether the defendant was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. I'll say that again. The danger need not have been actual. So it's actually legal to use deadly force against somebody, even if there's no real danger. The key is whether the person using the force reasonably believed that the danger was there. Now, I would submit to you there's no question that the danger was real. There's no question that the danger was imminent. But this instruction shows you that even in cases where there's no real danger, if you find that the person who used deadly force had reason to believe that there was a danger, that's enough. That's enough to say that the use of deadly force was justified and lawful. I'll keep reading. To justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Pedro told her, "You're going to have to kill me. I'm ready to die." What else was she supposed to believe? What else was she supposed to believe? She didn't put herself in that situation. He put her in that situation. The state will tell you, "Oh no, she brought him to the house, so it's her fault." No. She brought him to the house. She knew she was going to leave. First of all, she was supposed to pick him up and take him to his mother's house, but she explained to you she came back because he still had his keys. She wanted him to see the kids. She wanted to make it work so that she could get away from this man finally, move away from him, not have to deal with him beating her up. And she was implementing her plan. Whether it was a good plan or not, that's up to you to decide. But that was her plan. That's what you heard. It has not been refuted by the state in any way, shape, or form. She went to pick him up. She came over. She came over while her mother was there, and you heard from her mother and you heard from her. He was obviously high on cocaine because he used a bunch of cocaine at his friend's house. He bought a bunch of cocaine from his friend. He was drinking. You heard what was in his system when he died. He was extremely under the influence of a ridiculous amount of cocaine. He was drunk. He was out of control. She brought him back, and as soon as he started becoming violent, which he did on multiple occasions, as you heard from her mother and from her, as soon as that happened, he was told to leave. He was told, 5 different times to leave? And 5 different times he left. 5 different times he came back. You saw video of him running around. There's a video of him being told to leave a few hours before he was shot. How many times does this woman have to tell him to leave? Once is enough. Once is all it takes. It's my house. You need to leave. You need to leave. If you don't leave, you're committing a crime by not leaving. Okay? You're committing a crime. But he knew that she didn't want to call the police on him. He knew that for whatever reason, and she shouldn't have, but for whatever reason, unfortunately, she had a soft spot for this man. And she kept giving him opportunity after opportunity, even though, as we all know, she probably shouldn't have. But again, relationships are complicated, and you can judge her all you want, you can disagree with her all you want, but you don't know what it was like for her. And that's the decision she made. And it's understandable because, again, relationships are complicated, and that's the position that she was in. But she didn't create this position. She asked him to leave. He put her in that position by coming back repeatedly. I'm at the bottom of page 9. The defendant is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another when using defensive force that was intended or likely to cause death or great bodily harm to another, if, this is important, A, the person against whom the defensive force was used was in the process of unlawfully and forcefully entering or had unlawfully and forcefully entered a dwelling, residence, or occupied vehicle. This is black and white. There's no room for interpretation here. You are presumed to be in reasonable fear and justified to use deadly force if somebody is in the process of unlawfully and forcefully entering your home. That is exactly what he was doing. And unless they can prove to you beyond all reasonable doubt that that's not what he was doing, then your verdict is not guilty. Anything other than that would be a disgrace. And I know you all don't want to make a disgrace here. I think you all want to get it right. There's only one right answer here, okay? I'm confident that you're going to get the right answer. I want to go to the next page. The next paragraph B. Defendant knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring. This goes hand in hand with the previous one. Reason to believe it was occurring. He told her he was going to do it. He told her, you're going to have to kill me. And she saw him doing it. And the blood trail which begins in front of that front door corroborates what she told you. The state has given you nothing to dispute or disprove that. The next paragraph, this is page 10, right over here. The very next paragraph talks about situations where the presumption of reasonable fear does not apply. Okay? So, if any of these examples, there's 4 examples, if any of them were to apply, then you could come to the conclusion that, okay, well then this person didn't have a reason to believe that she was in danger of something bad happening to her. I'm going to start with the last one, with D, because this one's easy. The person against whom the defensive force is used is law enforcement. Well, Pedro Jimenez is not a law enforcement official, so we know D doesn't apply. So you can scratch out D. D is useless to you, okay? C, the person who uses defensive force is engaged in a criminal activity or is using the residence to further a criminal activity. This doesn't apply either. Daisy was not using her home to conduct a criminal activity, and she was not committing a crime when she was just at home in her front yard, minding her own business. So C does not apply. You can disregard C. B, the person or persons sought to be removed is a child or grandchild. Pedro Jimenez is a grown man. He's a grown man who's 6'4" and weighs 250 or 60 pounds, and he could easily beat the crap out of Daisy whenever he wants, and he has on multiple occasions. So B doesn't apply. So all that's left is A. So let's read A. The person against whom the defensive force is used has the right to be or is a lawful resident of the residence, such as an owner, lessee, or title holder. Has the state proven to you, beyond a reasonable doubt, that Pedro is a lawful resident, owner, lessee, or title holder? No. They got up here and they told you over and over it was his home, he lived there, they were family. They can say it till they're blue in the face. They have to prove it. Have they proven it? No. The only proof you've received on that topic is that it wasn't his home. You have lease agreements that he's not on. You have his license that he's not on. You have testimony showing that the locks were changed. You have testimony that he lived at his mother's house. Would he go over there to see the kids? Yes, but that doesn't mean that he lived there. All the evidence that you've heard proves that he did not live there. At best, you can say, well, maybe he did, maybe he didn't. But if that's your conclusion, then it has not been proven beyond a reasonable doubt. And again, the state has to prove their case beyond a reasonable doubt. They have not done so. I want to focus on this paragraph, which is right after A, B, C, and D. A person who unlawfully and by force enters or attempts to enter another's residence is presumed to be doing so with the intent to commit an unlawful act involving force or violence. The fact that he was forcing his way into her house, according to this instruction, allows you to presume that he was doing so with the intent of committing a violent act and committing a crime, which is exactly what gives Daisy Link the right to use deadly force. And finally, and this is important, it's all important, but last paragraph, if you find that the defendant who, because of prior threats or difficulties with Pedro Jimenez, had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Pedro Jimenez, you may consider that fact in determining whether her actions were those of a reasonable person. They had prior difficulties. You know all about them. Isn't it reasonable for Daisy Link to fear that this man could hurt her, to fear that this man could kill her when he just did this to her a few days before? Yes, you can judge her for communicating with him and spending time with him in the intervening days, but as she said, number one, she loved him. That clouded her judgment. Number two, when he wasn't on drugs, there was no problem. The problem was when he was on drugs. And we know, without question, he was on a lot of drugs when she shot him. And what did she say? When he's on drugs, when he's on cocaine, he's a monster. And that's what he is. That's what he is. And finally, ladies and gentlemen, at the beginning, top of page 11, in considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capacities of the defendant and Pedro Jimenez. Pedro Jimenez is a man, Daisy Link is a woman. Daisy Link's not a petite woman, she's a larger woman, but Pedro Jimenez was a lot bigger than her, a lot stronger than her, a lot more dangerous than her, and he's proven that he could hurt her, and he did hurt her over and over and over again. You may not like her, you may disagree with her, you may think whatever you want to think. You may take exception to what she said on that video. You may do all that. But none of that changes the fact that at the time she fired that shot, that man was going to barricade himself inside that house. And according to the law which you all swore you would follow, she was justified in using deadly force.
Mr. Octala, can you go help him? It's your computer.
Can we stop the clock for this?
Yeah, of course. Yeah.
This is minutes before he gets shot. Look at him. Wandering around. It's 3-something in the morning. He's still wandering around, walking around aimlessly, thinking about how he's going to terrorize Daisy next, which he's been doing all day. Walking around. He's been told to leave 5 times. He's back again. You think he's back again for a good reason? You think he's back again to do something nice? You think he's back again to make up? No, he's back again to cause trouble. that sound like somebody who's in fear? No, that sounds like somebody who's coked out of his mind, somebody who likes to beat women up.
I'm just gonna.
Yeah.
May I proceed?
Yes.
Officer Edwards, nobody would have done this to him. I don't know who would. Except on cross-examination, what she said was, I shouldn't have, because she knew she had other options. She knew. If we take her at her word, and I think we can all agree there is absolutely zero reason to take her at her word at this point, lie after lie after lie, this happened 5 days ago. She says she spoke to the police. Maybe, maybe not. Lie after lie after lie. She shouldn't have. If that's true, despite the fact that on her phone, those videos conveniently aren't there, call the cops. Tell them. Let them know. Take your kids and flee. Your kids, your children, your 8-year-old and your 5-year-old, take them. Get them away from that dangerous man. That's what she wants you to believe. Instead, though, what does she do? According to her, he leaves. She goes in her car, goes back home, takes a nap. Day later, day after that, Pedro comes over. They sleep together. They mentioned that, I mentioned on my closing argument that I said that the defendant was upset that the victim wasn't home. They said that's not true, there's no evidence of that. That's actually not true. She says at some point in her statement, I don't have the timestamp, but she says in her statement, it's not fair. I told my mom it's not fair. He's always on the run, he's never home. She says directly to the officers, it's not fair, I'm upset. Almost beaten to death. These are horrible. Horrible. But as we heard, Daisy admitted she herself is an abuser. These are horrible, but these happened 5 days before. Was it going through her mind when she invited him over the day after, or the day after that? Was it going through her mind when she picked him up from a friend's house? It wasn't. She had forgotten about this. She even said it on the stand yesterday. How do we know it was their home? Well, ladies and gentlemen of the jury, Daisy Link told us it was yesterday. She said Pedro never had a key, except on cross, she said, well, actually, he may have. When he left, he probably had a key to my house. They lived together, how do we know? Well, here's the thing. On Pedro's address, it has a on his license, it has a certain address on it. But what else? It has that address on it, mail that was found in a car. With Daisy Link's name on it as well. They lived together. But you don't have to take the evidence like that, Pedro Jr. said the same thing. He said, my dad lives in my car, or his car, because he's a trucker, he's never home. So, when he's home, he lives here. Sleeps on the couch sometimes, sure. But this is his home. He said that as much. The court order, I'm sorry, the court order, this is what they thought of it. They thought it was trash. That's what they did with it. They threw it on the ground, they didn't care about it. How do we know that? It's on video. She's giving him more than what this says. This, to them, was trash. There is no termination of parental rights. They ignored it over and over and over again. The pistol whipping episode from 5 days ago, if you take her at her word, and you shouldn't, there is no reason to take Daisy Link at her word. If you take her at her word, it happened 5 days before. And then they slept together. And then she picked him up. And the interesting thing there about picking him up from a friend's house is she says, it's a drug den. There's prostitutes, there's drugs throughout. He's a monster on drugs. Well, we have it on video of them actually arriving back from that house. You tell me if that looks like an angry, aggressive man playing with his children. Apparently high on cocaine, according to Daisy at that point. A monster is what she said. Except she let that monster hang around her children. Play with them. Be around the house. The video that was destroyed, it wasn't some cover-up, it wasn't a conspiracy. They actually explained explicitly how. Sergeant Fernandez came in and explained she was called out on scene, plugged in a hard drive. It wasn't working, so what do? They have to take it back to headquarters. There is a specific program that they use, and she explained, if they run that program on that hard drive and plug it back in, it will delete everything. It will reset the hard drive. And so what do? They attempt and attempt and attempt to get that video, but they can't, and they give up. And so they return it back to the homeowner, who then plugs it back in. It's a full hard drive. It got reset. And finally, ladies and gentlemen, Daisy Link's story doesn't make any sense. And the reason it doesn't make any sense is because of the gunshot and how it traveled. Because what she says is, he was charging at me, and I fired. The only way this gunshot, this trajectory, makes any sense at all is if he is running away. That upwards trajectory, through the foot, in and in, through the thigh, in and out, clean as day, is if his back is turned and he is actually running away. Otherwise, you'd have an injury that way, to the front of his body. That's not what happened here.
30 more seconds.
We know what happened here. We know that Daisy Link purposely discharged that firearm at Pedro Jimenez as he fled her. The state has proven beyond a reasonable doubt that she is guilty of second-degree murder, and you should find her guilty as such. Thank you.
Thank you. I'm on page 19. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when you all have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any other person outside the jury room about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to seats where they would be guarded by the bailiff while you deliberate. You can send a note or a phone call to your loved ones, letting them know you're deliberating before Umberto takes those electronic devices. If you need to communicate with me, so from this point on, if you're going to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the lawyers before I answer. So it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. If there's something missing, send a note, or we'll try to communicate with you if there's anything that we needed to keep back with us. If you need extra copies of anything, such as the transcripts, let us know. I can make 6 copies for you all. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we share. You can keep those copies with you. One of them has to be signed and submitted by me to the clerk. I have 3 jurors, so I know that you all have been very dedicated. We can hear you laughing, so I think you all have become close since then. That's a good thing. But there's 3 dedicated jurors that will be leaving us. So you're going to go with Umberto up to my office. We have lunch for you. I'll shake your hand and thank you. It is Grace Rivas, Liseth del Carmen Meza, and Crystal. All right, jurors have left. Lawyers, please take a look at the exhibits. If there's a clean laptop, I'd like to send that back to them.
Judge, can I
That's
just
the
point
verdict
to
form.
Billow's quote real quick?
Oh, sure.
I'll clean up my mess.
All right, we can go off record. When Mr. Tomas comes back, we'll discuss.
A jury is deliberating the fate of Daisy Link right now, and we'll get back to watching those final closing arguments in Miami, Florida in just a moment. But first, let's get you an update out of Wisconsin. Closing arguments are about to get started there in the Caught in the Crossfire murder trial for Paris Larry Jr. Right now, the attorneys are working on final jury instructions. Larry was just 14 years old when this all happened. Prosecutors say he was involved with other people in the shooting that killed 20-year-old Tatiana Zek. She was shot in the head while she was taking out the trash after a cookout. 3 others were also injured as well. The defendant took the stand in his own defense at the last minute. The day before, he said he didn't want to testify, but he changed his mind, and he did say that he fired his gun, but said that he did it because he feared for his life.
So, why did you pull out that gun and fire it?
Keyshawn, I just saw Keyshawn and Johnston pulling out guns, and I was in fear for my life.
And you fired your gun before Keyshawn Johnson fired his gun, correct?
No.
And you fired almost simultaneous to Antonio Johnston, as you just said, correct?
Yes.
And one of your bullets could have been one of the bullets that killed Tatiana Zek, correct?
I object. Calls for speculation.
He has
Foundation.
personal knowledge of being there, pointing the gun, identifying where his gun is at the time. He can answer the question.
Overruled.
What do that mean?
That means you can answer the question.
Yes.
And one of your bullets could have been the one that hit Javier when he was in his apartment.
Yes.
We'll continue to follow that trial and bring you updates throughout the day. But let's go back to Florida, where a jury is already deliberating the fate of Daisy Link. Her attorneys say that she shot her boyfriend, Pedro Jimenez, her husband rather, in self-defense, arguing that the two were in this tumultuous relationship marred by abuse and domestic violence. Prosecutors say she was the aggressor. Let's pick it up where we left off with the closing arguments from the defense attorney telling this jury she was the victim, not the villain.
This is a court order. This court order says Pedro gets to see those kids once in person, see them in person, once a month with the supervision of his mother. Daisy had a fear, a reasonable fear, that if the court found out that she was allowing Pedro to see those kids in person, knowing that he's still being violent, knowing that he's still abusing drugs, a court could very easily and theoretically say, you know what, you're not supposed to have him around those kids, you know what he's doing, we're gonna take those kids away from you. As a parent, is there anything scarier? Anything scarier than losing your kids? I don't think so. You can think something, I'd love to hear. I can't think of anything. I'd rather be killed than lose my kids, personally. She feels the same way. That's why she did what she did. You can disagree with it. You can not like it. That's fine, that's your right. But that doesn't change the fact that at the time she pulled the trigger, she had every right to do so. This paper that you all have, jury instructions, this is the only law that applies in this case. There is no other law, no other instructions that apply to this case. You are to decide your verdict based on these instructions and these instructions alone. Okay? So let's go through the instructions. Page 3. This is a really loud one. I'm sorry, I can't have it. It's the best I can do, I'm sorry. Page 3. You all have it, so that helps. Justifiable homicide. Use of deadly force is justifiable if done while resisting an attempt to murder or commit a felony upon the defendant, in or upon any dwelling house which the defendant was at the time of the killing. Miss Link was at her home. She had every right to be there. Mr. Jimenez had no right to be there. I don't care if his kids were there. He had no right to be there. He had no right to see them. You saw the order. He did not live there. He did not have the keys. He was not on the lease. The address was not on his license. You've heard testimony from multiple people that he did not live there. You have not heard testimony from a single witness that said he lives there. They want you to believe he lives there because it's convenient for the case. They don't want you to believe that he didn't live there, which he didn't, because they know that if you know he didn't live there, they're done. Their case is over, and I'll explain that to you in a second. So the question is, has the state proven to you beyond a reasonable doubt that Pedro Jimenez lived in that house? No, they haven't. At best, maybe you can all say, yeah, I'm not sure. Maybe he did, maybe he did. What are they pointing to prove that he lived there? Because there are some shoes and some shirts that appear to be for males in the house? Does that prove he lived there? I'm sorry, it doesn't. And use your common sense, people, okay? I still have stuff at my old house, and I've been divorced for 10 years. It's still there. It's not my house. I don't live there. I don't have a key. I can't go there and come and go as I please. No, I have to knock on the door. I have to be allowed inside like everybody else. Was that my house before? Sure. It's not anymore. Do I still pay the mortgage? Yeah, I do, actually. But I still don't have a right to go in there because it's not my house anymore. That was not Pedro's house. And unless they prove that it was his house and that he lived there beyond a reasonable doubt, then no. Then as far as you're concerned, that was not his house. He didn't live there. He did not have a right to be there. Same page, page 3. Excusable homicide. The killing of a human being is excusable and therefore lawful. The killing is lawful, which means it's not illegal. It is lawful, not a crime. Under any one of these following circumstances, when the killing is committed by accident or misfortune, in doing any lawful act by any lawful means in the ordinary caution, okay? Number 2, when the killing occurs by accident and misfortune in the heat of passion, upon sudden and specific provocation. Can you see how that scenario could apply to this case?
The defense, they're going through the elements of the law, walking the jury through self-defense, murder. We'll hear if they go through manslaughter and whether they tell them that that would be a better choice than murder, but perhaps they will just stick to this is absolutely self-defense, nothing more. Let's bring in trial attorney and family law attorney Michelle Thomas. And I do want to let our viewers know, Michelle, in real time that the jury is getting a lot of information back into the deliberation room. We understand the court is getting together copies of transcripts and the complete autopsy photos and things of that nature. All the things that happen when a jury first starts deliberating. They make sure they have all of that information. The defense highlighted the cocaine in the shooting victim's system. How much does that impact things when we have a self-defense case?
Well, I think that it matters because in this case, she testified that when he was on drugs, that he became, quote unquote, a monster. And so would it be reasonable for her to believe that she was in danger and in imminent fear at the time of the altercation and that she pulled the trigger? So to the extent that he was on drugs in that moment, that makes her story and her narrative a bit more credible and plausible that she was justified in believing that she was in imminent fear and ultimately justified in killing.
And also this jury getting that police interview, that's going to give them a lot of that information that you're even talking about. What did she say initially to police? I also want to ask you about stand your ground, because the defense is getting really passionate in these moments that we were just hearing, and he's telling these jurors she had every right to be in her home. The judge denied a stand your ground claim initially, because that's a case that's almost separate from this case, a mini trial where the judge hears it and sees if it can even go to a jury. That was denied. So he can still talk about it, but it's not something that the jury's going to decide about. Stand your ground specifically, they're looking at, was this self-defense? Tell me your thoughts on, should this have been something that is a Florida stand your ground type case, because she was in her own home?
You know, I think that's a really interesting question. And I'm surprised at how much time actually that the defense counsel is spending on her ability to defend her own home and property. But he's really driving that point home. And so too, even though it wasn't initially ruled on as this being a stand your ground case and that she was justified, I do think that it puts into the jurors' minds that she may have been further justified in the killing because it was her home. She had every right to be there. And then critically, she had no a reason or requirement to retreat. So that she chose not to retreat, even though he was shot from the back, that would certainly bolster her claim as to why she should be acquitted on all counts.
Michelle Thomas, thanks for that analysis. Stand by. The jury continues to deliberate. They are 20 minutes in. We are continuing to watch the rest of the defense's closing argument in the toxic relationship murder trial in Miami, Florida for Daisy Link. Plus, we'll also get an update on another case that we're watching here on Court TV. Matt Johnson's going to join us for this one to get us up to speed to this one in Massachusetts. For a firefighter from Ireland, Terrence Crosby accused of rape. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us. We've been watching the Daisy Link case out of Florida. Before we get you back inside of that courtroom, we do want to keep you updated on our newest live trial happening in Massachusetts. We're calling it the firefighter rape trial. The defendant there is Terrence Crosby, a 38-year-old man from Ireland. He's on trial for the second time on charges that he raped a woman in a Boston hotel. He was visiting Boston with fellow firefighters at the time, according to prosecutors. And while we have been in Daisy Link, this trial has been going on. So we have with us Court TV crime and justice correspondent Matt Johnson, who has been watching it for us, making sure we don't miss any major moments. Matt, thanks for being with us. Let's talk about the opening statements. They started today while we were in the middle of another trial. What stood out?
Much anticipated opening statements, and they didn't disappoint. Powerful from both sides in this retrial for Terrence Crosby. The Commonwealth of Massachusetts calling the Irish firefighter a visiting predator who thought that he could get away with rape, while his defense team questions the victim's memory, her changing story, according to them, and intoxication level.
Through her testimony and all of the evidence that corroborates it, we will prove to you that the defendant went into that room, raped as she slept, and continued to do so after she woke up and struggled to get him off of her. The defendant thought being far from home meant no one would ever know what he did. But by the end of this trial, you will.
This case is going to involve a lot of suspicion and maybes and what ifs. It's going to involve a lot of emotion. But we do not convict people on suspicion. We don't convict people on maybes. We don't convict people on what ifs. We don't convict people on emotion. Mr. Crosby should go home not guilty.
The defendant there that he was pointing at, his client, appears engaged at the defense table, was in a suit and tie. He testified during the first trial, which is also what we expect this time around, Julia.
Certainly, because we got a situation where this was the defendant's hotel room. He legally could go inside. He says he got in a bed and didn't know that she was not there for him. So I think a lot of people are wondering, what's the DNA? There's a rape kit that she got at the hospital. What does that say?
Well, that's going to be key to this case more than most cases. The DNA evidence, much talked about during opening statements, both sides using it to their advantage. Take a listen.
DNA testing was later done on swabs from her genital area. 2 distinct male DNA profiles were found in one of those genital swabs. And while there was an insufficient amount of male DNA to compare it to a known person, there was enough to show that the DNA was left behind by 2 different males.
Not a single time did they find a trace of did they find a trace of Terrence Crosby's DNA? Not inside her, not outside her, not on her clothes, nowhere. The only identified male DNA found came from the other person in that room that night, Liam O'Brien.
We should also mention that when we drop the audio there, we are not identifying the victim in this case. That's per court order, so we're, of course, following that. Okay, so the attorneys also mentioned surveillance video from the bars, the hotel in question where this alleged event took place, and the flight that was booked by this defendant when he changed his flight to catch an earlier flight on a different airline after speaking with investigators. How much they get into with that during the trial will be very interesting.
Consciousness of guilt, perhaps. We know he was deemed a flight risk in terms of where he is able to move about if he gets out of jail. Let's talk about the jury makeup, because we got a situation where there was a mistrial the first time. Jury couldn't come to a decision. Who's on the jury this time?
Yeah, and during that first time, the jury deliberated for something like 22 hours before it was declared a mistrial. Here in the Boston area, it was 2 days of of jury selection. The jury was asked their thoughts on immigration, people with Irish accents because he's expected to testify, and infidelity because he is married. Well, take a look. Here is the jury makeup. 8 men and 7 women. That includes the 3 alternates hearing the case. They're in the box right now. This defendant faces up to 20 years behind bars if convicted. As I already mentioned, he is married with children. His wife has been by his side during prior court proceedings, but she was not spotted in court today, according to our field producer.
A really interesting case, Matt. Thank you for watching it, monitoring it. We will get our viewers into it as soon as we wrap things up in Florida. Thanks so much. Still with us, speaking of that Florida case, the Daisy Link case, let's bring in trial and family law attorney Michelle Thomas, because Michelle, we've been watching the closing arguments in Daisy Link, and we understand that the jury, they in real time have been deliberating for 31 minutes, but they have a question, and they are about to go on the record inside of the courtroom to talk about their question. So we are going to take everyone in there as soon as we get audio inside of that courtroom. But while we wait for Daisy Link, do you have any comments you want to make on this rape trial that Matt Johnson just talked about?
Well, that's a really fascinating one. I mean, and it really comes down to credibility. Here we have an alleged victim who went straight to the hospital. She obtained a rape kit. I mean, she took the steps necessary, but then you have the defendant who's denying it all. And so I'm really interested in how this one's going to unfold.
Oh, yeah. Okay, we're going to take a break. And when we come back, we should have live coverage inside of that courtroom in Miami, where the jury has a question in the case where they are deliberating over whether it was self-defense, murder, or manslaughter for Daisy Link.
I'm going to ask you a lot of intensely personal questions. How do you explain it? The worst crime anyone can imagine. Do you feel like you took the fall for this murder? Tell me in your own words, what happened? Let's get started.
Interview with a Killer. New season premieres Saturday, October 25th. Only on Court TV.
Welcome back to Court TV Live. We have breaking news out of California in the case of baby Emmanuel Haro. You'll remember that he went missing August 14th, and his parents initially said they didn't know anything about what happened to their child, that their child had been kidnapped by someone. Ultimately, on September 4th, they were arrested and charged with murder, and we're now getting multiple reports that confirm that the father of the missing 7-month-old has pleaded guilty to all charges, including second-degree murder. Jake Haro entered that guilty plea during what was scheduled as a felony settlement conference there inside the courtroom. That often happens in a case before it goes to trial. Reporters in the courtroom say Haro was visibly emotional, crying as he admitted to killing his infant son. Emmanuel's remains have not been located. Jake Haro's sentencing is scheduled for November 3rd. His wife, Rebecca Haro, who also faces murder charges in connection to the case, she continues to plead not guilty. According to what we know on the record, her felony settlement conference, similar to this one, has been scheduled for October 28th. Court TV will continue to follow this story and bring you all of the latest right here. Now let's turn our attention back to Florida for the toxic relationship murder trial for Daisy Link. The jury has been deliberating now in real time for 37 minutes. We got word earlier that they had a question, but they haven't gone on the record yet inside of the courtroom to talk about that question. Earlier this week, Link did take the stand in her own defense. She testified that Pedro Jimenez was an abusive and out-of-control partner. She said she shot him in self-defense, but the prosecution says she was the aggressor and that she lied about everything to police until she was confronted with those lies. So it is now in the hands of a jury. They've got to decide if this was self-defense, murder, or manslaughter. For now, we've been looking back at the defense team's closing arguments, playing it all out for you. So let's pick it up where we left off. This is the defense attorney for Daisy Link.
She grabbed the gun, she told him, leave. And you heard what he said. I'm not leaving, I want to die, I'm ready to die. And then he ran to go break into the house. Then she fired. And then, and only then, when she fired, that's when he started running away. It took the shot, it took her firing the gun for him to abandon his intention to break into her house. And if you are stopping somebody from breaking into your house, that is justifiable use of deadly force. And it was going to happen imminently. We know that. We saw the blood trail, we heard the testimony. He was going to break into her house. She did everything she could to stop him. He refused, so she fired the gun. And it worked, because when she fired the gun, he ran off to the alley. I want to talk about the instruction for second-degree murder. This is on page 4. You see it there. Three elements that the state has to prove beyond a reasonable doubt in order for you to be able to convict Daisy Link. And this is what your case is going to come down to. Number 2, the death was caused by the criminal act of the defendant. And number 3, there was an unlawful killing. So, I highlighted the relevant portions in 2 and 3, just to give you all a little guidance there. So, in order for you to convict her of anything, whether it's murder or manslaughter, of anything, you have to find that her firing that gun was a criminal act and that her killing Pedro was unlawful. So, in other words, what your deliberations are going to come down to is whether or not this killing was justified or not. Was Daisy justified in using deadly force or not? That's it. That's the decision you have to make, and that's going to be how you reach your verdict, okay? It says it right there. So, let's fast forward. This is the key instruction in this case, ladies and gentlemen, page 8. It's the longest instruction out of all of them. It's, oh boy, look at that, it's 3 pages. It's 3 pages long. So, sorry, but we need to go through it. Justifiable use of deadly force. Third paragraph, okay? Defendant does not have the burden of proving that she was justified in using deadly force. Instead, for you to find her guilty, the state must prove beyond a reasonable doubt that she was not justified. This is what I said earlier. I don't have to prove that she was justified. It's the other way around. They have to prove she was not justified. So have they proven that she's not justified? Have they proven it beyond all reasonable doubt? Well, let's see. Let's have a look. Keep reading. The law on justifiable use of deadly force is as follows. Defendant is justified in using deadly force if she reasonably believed that such force was necessary to prevent the following: imminent death of great bodily harm to herself or another. So if she believes that imminently means it's about to happen, it's going to happen any moment now, that she's going to get hurt or another person's going to get hurt, you have the right to use deadly force in that instance. Okay? And then there's another option. Or B, the imminent commission of burglary or false imprisonment against herself or another. At the time that she shot, Pedro Jimenez was running to break into her house, to barricade her out of her house. Okay? He had no right to be there. When you enter somebody's house without permission, that's burglary. I'm going to read you the definition of burglary in a moment. So that's number one. That's one felony that he was about to commit, which, according to this instruction, if she knows that he's about to commit a burglary upon her house, she has the right to shoot him, to stop him. This is the law that you are required to follow. In addition to burglary, false imprisonment. There are 2 kids in that house. Those kids are in her custody, not in Pedro's custody, her custody. By barricading himself inside the house, Pedro would be illegally separating those kids by force from their mother, without permission, without authority, without any right to do so. She has a right to use deadly force if she has reason to believe that that's about to happen. And we all know that that was about to happen. He was about to burglarize her home. He was about to lock her out of her home and commit false imprisonment upon her kids. So, moving on to the next part. This long paragraph here, right here on page 4, on page 8, this paragraph has to do with whether or not Daisy Link had a duty to retreat or not a duty to retreat. You can go through that and read it to yourself, but ladies and gentlemen, as you will see in a moment, she had no duty to retreat because she had every right to be there because that was her home. On the other hand, Pedro Jimenez had no right to be there because that was not his home. He had been told repeatedly to leave. He had been threatened that they would call the police. And he did leave, but he kept coming back. Multiple times, he kept coming back, kept terrorizing this woman. She did it while her mother was there, and then he did it again after his mother left. His mother left at 1:32 in the morning, and he still came back after that. He's terrorizing her at 3 o'clock, 3-something in the morning. I'm going to refer you to page 8 at the bottom right here. If the defendant was in a dwelling or residence in which she had a right to be, which she did, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent death or great bodily harm to herself or another, or the imminent commission of a burglary or a false imprisonment against herself or another. So again, this says, again, if she has reason to believe, well, first of all, it says if she's in a place where she has a right to be, there's no question she had every right to be there. That was her home. She's in a place where she has a right to be. She can use deadly force to stop somebody from burglarizing her home and to stop somebody from keeping her outside of the home and keeping her away from her kids who are inside the home. She had a right to use deadly force in each of those and in both of those. This is the law that you are required to follow. After this defines the crimes of burglary and false imprisonment. These are the two crimes that I would submit to you. The evidence has clearly demonstrated Pedro Jimenez was intent on doing and was in the process of doing, and the only reason he stopped from doing it is because she fired that shot. That was...
Hitting the pause button on this so we can bring back in trial and family law attorney Michelle Thomas. We're about to get to our break, Michelle, but what do you think about how the defense is laying this out? He's even laying out the crimes that the alleged victim in this case would have done. What's the jury going to come back with here, in your opinion? Self-defense, not guilty, manslaughter, or murder?
You know, I mean, I think that the defense is doing a compelling job. I mean, he's like, even though stand your ground wasn't formally granted as a defense, he's laying out the basis, the foundation for why she was legally in the right to shoot him. It's really was like a preemptive act that she made. So I think that the jury's going to be, it's going to be really difficult here because she was in her own home. There were threatening acts made. She represented that she believed he was going to run into the home and barricade, the children and possibly do harm to her or the kids. And so she then, under those circumstances, had a right to kill him. So I think it's going to be really difficult for this jury to parse through whether that defense is essentially enough to acquit her, or they're going to say that find her not credible and it's going to be murder.
48 minutes they've been at it. Michelle Thomas, thanks so much. We're still getting word about that jury question. They haven't gone on the record. More of the closing arguments and monitoring this case after this.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, of course, honored to be with you. And we have breaking news. Court TV can now confirm that the father of missing 7-year-old Emmanuel Haro has admitted to killing his son. Just moments ago, we got the court documents that say Jake Haro, there he is, has pleaded guilty to all charges, including second-degree murder. Reporters in the courtroom say that at today's hearing, Haro was visibly emotional, crying as he admitted to killing his own infant son. Jake Haro will return to court on November 3rd, next month, for sentencing. Now, his wife, Rebecca, she also faces murder charges in connection with the case. So far, no details yet as to whether or not she will change her plea. Her next court date is this month. That is set for October 28th. Baby Emmanuel was reported missing back in May. His remains have not been located. Hopefully that will be coming. Let's bring in now criminal defense attorney Laura Yaretzi. And Laura, good. I'm glad that he has entered a plea if he did this, which he says he did, murdered his own infant son, but still the missing piece of where the body is. What are your thoughts?
There's always a possibility that he may cooperate with the prosecution and law enforcement to get some leniency as far as sentencing is concerned. And as part of that, he may tell them where the remains are, or give them specifics as far as what happened.
That's right. That's what we're hoping for in the name of justice for this little beautiful baby boy. And the reality of, what do you think about, because we've seen cases in which a defendant is either convicted of murder of a child or in the alternative pleads guilty to murder of a child, but they don't show emotion. The reporter inside the courtroom has said he was very emotional as he entered this plea. Does that say anything to you?
I mean, it shows you that that's a father who's lost a child, but it may mean that maybe there was some negligence or accidental killing, or maybe he wasn't in the right state of mind, or he was under the influence of drugs. This is somebody who basically cares or cared about the child and is showing emotions, and maybe he's basically feeling sorry for what he did. And that could go a long way. Remorse is important in cases like this.
Yes, and we'll see whether or not there's more remorse shown by the father. Again, he has pled guilty to the murdering his own son, Emmanuel. All right, now we want to turn back to Florida, where a jury has begun deliberating the fate of Daisy Link. We hear the jury has a question. Of course, we will take you there live once the court resumes and goes back on the record. Attorneys for Daisy Link says that she shot her boyfriend, Pedro Jimenez, in self-defense, arguing that the two were in a tumultuous relationship marred by abuse and domestic violence, including pistol whipping. But prosecutors believe that Link was the aggressor. While we wait for that verdict to come down or the question the jury may have, we are watching the defense team's closing argument. We want to bring all of that to you in its entirety. Let's go back in for more.
That was the only way that she was going to stop him from doing that. And we know that from Pedro Jimenez himself. I'm ready to die. What does that mean? I'm going to do what I want. You want to stop me? You're going to have to kill me. You're going to have to kill me. Burglary. Entering a dwelling owned by or in the possession of another, and at the time of entering the dwelling, the unauthorized person had the intent to commit the crime of false imprisonment. Please tell me, how has the state disproven that this was about to happen? Can you honestly say to me that the state has convinced you beyond all reasonable doubt that Pedro Jimenez was not in the process of rushing in to barricade himself inside that house and lock Daisy Link out? Have they disproven that beyond a reasonable doubt? If the answer is no, then your verdict is not guilty. If the answer is yes, then okay, then I would ask you to ask yourself, how have they proven it? What have they shown you? What have they introduced to prove that? I would submit to you they've introduced nothing. Nothing to disprove that that man was going to do that. Certainly not beyond a reasonable doubt. That's burglary. False imprisonment. That's the next one. We're still on page 9. It's right here. False imprisonment is defined as follows. To forcibly or secretly confine or abduct another person without lawful authority to do so. Forcibly would apply here. He was attempting to forcibly confine those kids within that house and keep the mother out of the house. The next paragraph defines secretly. You're free to read that as much as you want, but secretly doesn't apply here, so I'm not concerned with that. The next paragraph is very important. Very important. Confinement of a child under the age of 13 is against the child's will if such confinement is without the consent of the child's parent or legal guardian. In other words, if you're locking 2 kids inside a house against the will of those kids' legal guardian, and those kids are under the age of 13, which, as you already know, those kids were ages 7 and 5 at the time, then that's false imprisonment. We know that Pedro was not their legal guardian because that's what this order says. So unless the state is going to come up here and find a way to invalidate this court order, which if they have a way to do that, I'd love to hear it. They're not going to. This is a court order, this is a valid court order, and this court order was in place, in full force, on that night. Daisy Link asked him to leave. He did not respect her request to leave. He was going to commit false imprisonment. And that is what this instruction tells you. I'm going to keep reading. Please bear with me, but again, this is a long instruction, but it is the most important instruction in this case, because this is what your deliberations are going to come down to. In deciding whether the defendant was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. I'll say that again. The danger need not have been actual. So it's actually legal to use deadly force against somebody, even if there's no real danger. The key is whether the person using the force reasonably believed that the danger was there. Now, I would submit to you there's no question that the danger was real. There's no question that the danger was imminent. But this instruction shows you that even in cases where there's no real danger, if you find that the person who used deadly force had reason to believe that there was a danger, that's enough. That's enough to say that the use of deadly force was justified and lawful. I'll keep reading. To justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Pedro told her, "You're going to have to kill me. I'm ready to die." What else was she supposed to believe? What else was she supposed to believe? She didn't put herself in that situation. He put her in that situation. The state will tell you, "Oh no, she brought him to the house, so it's her fault." No, she brought him to the house. She knew she was going to leave. First of all, she was supposed to pick him up and take him to his mother's house, but she explained to you she came back because he still had his keys. She wanted him to see the kids. She wanted to make it work so that she could get away from this man finally, move away from him, not have to deal with him beating her up. And she was implementing her plan. Whether it was a good plan or not, that's up to you to decide. But that was her plan. That's what you heard. It has not been refuted by the state in any way, shape, or form. She went to pick him up. She came over. She came over while her mother was there, and you heard from her mother and you heard from her. He was obviously high on cocaine because he used a bunch of cocaine at his friend's house. He bought a bunch of cocaine from his friend. He was drinking. You heard what was in his system when he died. He was extremely under the influence of a ridiculous amount of cocaine. He was drunk. He was out of control. She brought him back, and as soon as he started becoming violent, which he did on multiple occasions, as you heard from her mother and from her, as soon as that happened, he was told to leave. He was told, 5 different times to leave? And 5 different times he left. 5 different times he came back. You saw video of him running around. There's a video of him being told to leave a few hours before he was shot. How many times does this woman have to tell him to leave? Once is enough. Once is all it takes. It's my house. You need to leave.
The defense arguing to the jury some of the jury instructions, including, listen, you have to ask yourself, was the defendant justified in using deadly force, and that danger does not need to be actual. Tell us what you think. Go into social media, weigh in. The jury currently is deciding the fate of Daisy Link. We're just bringing the closing arguments to you in their entirety. We'll have more of the defense's closing argument right after this short break.
Tonight on Closing Arguments, a parent's worst nightmare. A 5-year-old girl left unrecognizable after she was brutally beaten by other children. We'll dive deeper into this tragic case.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Donna Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
On June 25th, 2022, Pedro Jimenez was murdered. He was murdered by his 9-year relationship, his spouse, his wife, his defendant, Daisy Link. This is a toxic relationship. Two people that should have never been together. Ms. Link said Pedro Jimenez was a good guy. I disagree. I don't think he was a good guy. But he did deserve to be murdered that day.
Back now to Florida, where deliberations remain underway for defendant Daisy Link as she stands trial in the shooting death of her boyfriend. We have the clock up. It's been about an hour and 10 minutes. Link did take the stand yesterday where she testified that she shot at Pedro in an effort to scare him off, not realizing that she would actually hit him. Pedro was shot in the foot, which then traveled through his leg, hitting an artery and causing him to die. Now, while we are waiting for the jury to return after they told the judge that they have a question while they're deliberating, the court is now back on the record without the jury present. Let's go in and listen together.
We're back on the record. Do me a favor, take those photographs and show them to your client. So Ms. Link's back on record. Ms. Link is here, Mr. Tomas, Mr. Brigida, Mr. Octala. Jury's still deliberating. We dealt with one question regarding, the full question escapes me now. They're referencing evidence of a back door. The lawyers and I reasonably believe that it's probably a photograph that Mr. Brigida, you referenced in your closing as a demonstrative aid. You've printed out those photographs. Mr. Tomas has them now.
And Judge,
Hold on. And then Mayor Elise, I'm gonna have those 5 as a composite for now. Mr. Tomas, I'm gonna give them back to you. Let the clerk mark them as a composite.
before we do that, I need to swap out a photograph.
So there's 5 right now, but one of them's a duplicate?
Correct.
You only want me to mark it, right? Just mark it for now. 2G. So the substance of the photographs that the state referenced in their closing are the outside of Miss Daisy's home, which encompasses a duplex. There is a 5th one that, Mr. Tomas, you found in your discovery.
Yes, ma'am.
And what does that one show?
So that one shows inside, shows the home, shows the door, I believe it's the back door, and very close to the back door there's a window that you can tell it's in place of glass, there are other things there.
Cardboard.
And this would, I think this would go towards the specific question that the jury asked about, I think they were alluding to the testimony that Pedro stuck his hand through the window to unlock the door.
Because at one point during the state's closing, some reference was made about how tall he was, and Mr. Brigida is not as tall as him. Something along those lines. If you remember it better than me, let me know. But something along the lines of reaching in and how nothing of the outside. The inference was nothing on the outside was damaged. From where I was sitting, that was the gist of the state's closing argument on that point.
Yeah, I recall, I guess the impression that I got was that this that I'm showing you shows that he couldn't have reached in and opened the door.
I got the same impression. But those photographs that were used as a demonstrative aid are not in evidence?
Well, so yes and no. When I was creating this presentation yesterday, I have a good faith basis to believe that at least some, if not all, of these photos are in evidence. I obviously do not have access to evidence once we are done for the day. I have reason to believe, based off of the testimony, as well as the introduction, as well as the conversations I've had with co-counsels, that those photographs were introduced. The other photograph, I am 100% my fault. I missed it. Mr. Tomas brought it to my attention when we were outside of the hall, I believe. I would not have made the argument that I had made. I would have changed it a little bit. It would have been something similar, but I still would have made the same argument. But I still have reason to believe those 4 should be.
So just print out the duplicate one. Are you going to go get it for us, Mr. Octala?
Yes, Your Honor. I'll go to the back. Or no, actually I have to go across the street to go and grab it.
Can you make your way over there now?
Yes, Your Honor.
Thank you. So How else do I fix this?
I don't believe it's fundamental error, Your Honor. I understand your concerns. I genuinely do, and I lean conservative when it comes to. No, I'm sorry. I lean very conservative when it comes to those kinds of things. It wasn't a predominant feature of my closing.
This is the first question that the jury. They're in there for maybe 10 or 15 minutes, and that was the first question that they had for us.
I understand. If the court wants to send an instruction back.
Why don't do you have any other suggestions?
I mean, I think by agreement we can send in those photos, but I don't know what else the court had in mind.
By agreement, you referenced the tattoo of Daisy on his arm. That was part of the autopsy. That photo may not have been part of the evidence. By agreement of the parties, we agreed because it was referenced in the autopsy. It went back a stipulation. That was number 30 what? 31. This is a little different. It's one thing for them to be in a 9-year relationship. They've got 2 kids. They love each other. There's ups and downs. Him having Daisy on his arm, that corroborates parts of the state's case, doesn't go to the core of either the elements of the crime or the defense to the crime. This does, because it goes to credibility of witnesses. Why shouldn't I bring this jury out and allow Mr. Tomas a minute to explain to them his version of that photograph?
That's fine. So the only issue is with that, and genuinely, like, I understand the court's concerns. I have the same concerns. Had I known that this photograph with the back door existed, and it's 100% my screw up. I am completely at fault.
Listen, I take you at your word.
I missed this. I would have still used this photograph, and I would have explained the same exact thing. I don't have an issue with Mr. Tomas being able to explain his version of events.
What would you have explained?
I would have said the window is still far from the door, and that this window appears like it was fixed, and if all of this was going on in the middle of the night, do we really think that this got fixed between the time and the shooting? That's what the argument I would have made.
But your argument is premised upon what you remember of these witnesses saying he stuck his hand through the door that day. I don't remember that specifically.
No, I believe the defendant's mother said that happened that night in between her being choked, or not the defendant's mother being choked, but the defendant being choked.
I don't remember. What do you remember? Why don't you confer with your client also?
The jury's asking for a lot after an hour. Let's bring in criminal defense attorney Laura Yaretzian just to recap what the jury's looking for. And the judge said, first of all, getting 6 copies and copies of the transcripts, as well as composite autopsy photos. The jury asked about a picture showing the back door, so there's debate between the attorneys and the court about that. Also, a demonstrative aid. It was an autopsy poster that was used as a demonstrative aid, and the judge said, send it all back to the jury. Laura, to me, this means they're digging deep into the self-defense claim to really figure out if they believe that was the case.
And that's exactly what I see here too. This isn't just one item, a discovery item that they're asking for, or evidence that they're asking for. They're asking for a number of things, and one of these items, there seems to be an issue, and the judge is very concerned about because she, and the jury is clearly focused on it, because she believes that there may have been a misrepresentation, and it may not have been an intentional misrepresentation or version by the prosecution, and now she's considering giving the defense an opportunity to maybe even have a 1-minute closing argument to address that. This is a jury that's taken its job very seriously. These jurors, if this was a slam dunk, we wouldn't have so many questions, right? We wouldn't have the jury asking for a demonstrative aid. They wouldn't be asking for transcripts. We're talking about several transcripts, photos, you name it. This is a good sign for the defense.
And I would agree that the evidence presented warrants a deep dive, because Certainly, I think both sides have very legitimate arguments based on the evidence presented. So I agree with you. The jury is doing their job. Let me ask you this, because I really appreciate that the prosecutor said, I had a good faith basis to believe photos were in evidence when I was creating our demonstrative aid. She said, but the problem is I didn't actually have access to the photos when I did it. And here's what she says to the judge, and I want to use her words because I'm impressed. This is how it should work in a court of law. She said, and I apologize, I can't find the, oh, here it is. I screwed up. I made a mistake. I'll do whatever the jury wants and take it on the chin. The reality is we're people, and when we're in there, it is so much work to prepare for a trial, to try a case. It's exhausting, no matter how prepared you are. So I appreciate she was just honest with the court. What do you think?
And yes, and like you said, we're all human, but then you have to remember, if there's a mistake that could influence or impact the jury decision one way or the other, that could be problematic later on. So if it's something, if it's an error of some sort that can be corrected, now this is the time to do it. Otherwise, it may be too late. And if there's a conviction, depending on how material and how exonerating that evidence is, or if it's very incriminating and the jury's considering it and it shouldn't have been presented, then that could be reason for overturning a conviction. So the judge has to, I understand she's taking the human side of it and a mistake and admitting to all of that, but it is important to also address the issue now.
I agree with you, and I think any judge knows they need to address it now. They need to make a record of the decision they make for the reason they make it. And if it's correctable now, much, much better than leaving it open as an appellate issue. All right, Laura, stand by, please. Up next, we're going to take a quick break, but we are bringing you the defense closing arguments in their entirety. We'll be right back. Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you so much for being with us. We are covering a lot for you right now. We want to return to Miami, Florida for more closing arguments in the toxic relationship murder trial for the defendant Daisy Link. The jury has now been deliberating for 1 hour and 25 minutes. Now, they had a question. They asked for some photos presented during closing arguments that had not been presented as evidence in the trial. Now, both sides and the judge discussed it outside the jury's presence, and the judge ruled that the photos will be admitted so the jury will get to see those. In this case, Daisy Link is a 30-year-old accused of shooting and killing her on-again, off-again partner, Pedro Jimenez, in June of 2022. As we mentioned, the jury now has the case, but right now we want to bring you more of the defense's closing argument.
It's my house. You need to leave. You need to leave. If you don't leave, you're committing a crime by not leaving, okay? You're committing a crime. But he knew that she didn't want to call the police on him. He knew that for whatever reason, and she shouldn't have, but for whatever reason, unfortunately, she had a soft spot for this man, and she kept giving him opportunity after opportunity, even though, as we all know, she probably shouldn't have. But again, relationships are complicated, and you can judge her all you want, you can disagree with her all you want, but you don't know what it was like for her. And that's the decision she made. And it's understandable because, again, relationships are complicated, and that's the position that she was in. But she didn't create this position. She asked him to leave. He put her in that position by coming back repeatedly. I'm at the bottom of page 9. The defendant is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another when using defensive force that was intended or likely to cause death or great bodily harm to another if, this is important, A, the person against whom the defensive force was used was in the process of unlawfully and forcefully entering or had unlawfully and forcefully entered a dwelling, residence, or occupied vehicle. This is black and white. There's no room for interpretation here. You are presumed to be in reasonable fear and justified to use deadly force if somebody is in the process of unlawfully and forcefully entering your home. That is exactly what he was doing. And unless they can prove to you beyond all reasonable doubt that that's not what he was doing, then your verdict is not guilty. Anything other than that would be a disgrace. And I know you all don't want to make a disgrace here. I think you all want to get it right. There's only one right answer here, okay? I'm confident that you're going to get the right answer. I want to go to the next page. The next paragraph B. Defendant knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring. This goes hand in hand with the previous one. Reason to believe it was occurring. He told her he was going to do it. He told her, you're going to have to kill me. And she saw him doing it. And the blood trail which begins in front of that front door corroborates what she told you. The state has given you nothing to dispute or disprove that. The next paragraph, this is page 10, right over here. The very next paragraph talks about situations where the presumption of reasonable fear does not apply. Okay? So, if any of these examples, there's 4 examples. If any of them were to apply, then you could come to the conclusion that, okay, well then this person didn't have a reason to believe that she was in danger of something bad happening to her. I'm going to start with the last one, with D, because this one's easy. The person against whom the defensive force is used is law enforcement. Look, Pedro Jimenez is not a law enforcement official, so we know D doesn't apply. So you can scratch out D. D is useless to you, okay? C, the person who uses defensive force is engaged in a criminal activity or is using the residence to further a criminal activity. This doesn't apply either. Daisy was not using her home to conduct a criminal activity, and she was not committing a crime when she was just at home in her front yard, minding her own business. So C does not apply. You can disregard C. B, the person or persons sought to be removed is a child or grandchild. Pedro Jimenez is a grown man. He's a grown man who's 6'4" and weighs 250 or 60 pounds, and he could easily beat the crap out of Daisy whenever he wants, and he has on multiple occasions. So B doesn't apply. So all that's left is A. So let's read A. The person against whom the defensive force is used has the right to be or is a lawful resident of the residence, such as an owner, lessee, or title holder. Has the state proven to you, beyond a reasonable doubt, that Pedro is a lawful resident, owner, lessee, or title holder? No. They got up here and they told you over and over it was his home, he lived there, they were family. They can say it till they're blue in the face. They have to prove it. Have they proven it? No. The only proof you've received on that topic is that it wasn't his home. You have lease agreements that he's not on. You have his license that he's not on. You have testimony showing that the locks were changed. You have testimony that he lived at his mother's house. Would he go over there to see the kids? Yes, but that doesn't mean that he lived there. All the evidence that you've heard proves that he did not live there. At best, you can say, well, maybe he did, maybe he didn't. But if that's your conclusion, then it has not been proven beyond a reasonable doubt. And again, the state has to prove their case beyond a reasonable doubt. They have not done so. I want to focus on this paragraph, which is right after A, B, C, and D. A person who unlawfully and by force enters or attempts to enter another's residence is presumed to be doing so with the intent to commit an unlawful act involving force or violence. The fact that he was...
All right, we need to take a break. When we come back, we will bring you the state's rebuttal closing. They get the last word. What do they tell the jury? Stay tuned.
Tonight on Closing Arguments, a parent's worst nightmare. A 5-year-old girl left unrecognizable after she was brutally beaten by other children. We'll dive deeper into this tragic case.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Donna Edelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Welcome back. We have breaking news. Florida versus Daisy Link. There's a verdict. 1 hour, 37 minutes. We have just heard this, so we're not going in the courtroom yet. They're not there. They're not ready, but we will be bringing you that verdict. They just, a few minutes ago, asked for information from the court, and the court had just determined that photos that were used as a demonstrative aid were going to be admitted into evidence and given to the jurors, and that included perhaps some autopsy photos as well as a photo of a back door that the jury asked about. Let me bring back in Laura Yaretsian. We just went through, this is what they're asking for, the judge determining with the attorneys outside the presence of the jury, this is what I'm going to do. I'm going to admit these pictures and give it to the jury. And then we hear pretty immediately, they've got a verdict. What do you think it might be in this case at 1 hour, 37 minutes?
That's an interesting one. Usually you don't see this because when a jury asks for evidence, they wait, and then the judge makes, together with the attorneys, they make a decision as far as what's going to be provided to them, if it's some language, if it's evidence. And after that, they go back in, they deliberate some more and come back. It looks like someone at least wanted to look, someone from that jury wanted to review this evidence or the demonstrative aid again. But for some reason, whatever question they had must have been answered, and they don't need to look at any of this anymore, and they've come to their decision. So it could have been just one person trying to confirm, maybe it was 11 to 1, when
Lawyers are present as well as Ms. Link. Jury is telling us they have a verdict. I'm going to bring them in. Before we publish, I may publish. Before we publish, listen, the lawyers did a good job. I know there's family members on both sides. We will all keep our calm and composure. I'm not going to say it again. Anyone who disrupts these court proceedings will be immediately removed, number one. Number two, the jury did their job. They will not be felt one way or the other influenced by anyone's reaction. Okay, let's bring them in.
All right, the jurors.
Alrighty, all jurors are accounted for. We can be seated. Mr. Bowie, you're a foreperson. Yeah.
Yes.
Bowie, you have a verdict. Yes. So I'm going to review it just to make sure everything's been checked off appropriately. After, if it's all in order, the clerk will ask you each one if this is your verdict, and then we'll take it from there, okay? Okay, all right, Ms. Link. The state of Florida versus Daisy Link, case number F2211523. Verdict, we the jury in Miami-Dade County, Florida, find the defendant, Daisy Link, as to count 1, second-degree murder, guilty of second-degree murder. If you find the defendant guilty of second-degree murder, you must answer each of the following questions. Number 1, did the defendant actually possess a firearm during the commission of the crime? Yes. Number 2, did the defendant discharge a firearm during the commission of the crime? Yes. 3, did the defendant discharge a firearm causing death during the commission of the crime? Yes. So say we all, the 16th day of October 2025, signed by the foreperson. All right, Marilise, we're going to poll the jury.
The jury, you heard the judge read the verdict. As I call your name, if this is your verdict, please answer yes. If this is not your verdict, please answer no. Keenan Bowie?
Yes.
Ramona Espinosa? Jacqueline Smith?
Yes.
Tiara Campbell?
Yes.
Esther Montoro?
Yes.
Lawrence Vega?
Yes.
Judge, the jury succeeded.
Okay. I just have one more thing I have to read to you all. Let me just. Privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. And with that, I thank you again. Please go outside with Humberto. I have a certificate of appreciation for you. I'll shake your hand. We'll give you back your electronic devices.
Judge, before you do that, can you start writing? I apologize.
Sure. Okay, now we can all rise and you all can go outside with Humberto.
Anything in the back? No. Follow me, please.
All right, folks, we can go off record for 2 minutes. I'll be right back. We're back on record. Lawyers are present, as well as Ms. Link. All right, Ms. Link, the jury's found you guilty. I will adjudicate you guilty. I'm inclined to defer sentencing for another day.
So the defendant is not a convicted felon. She has several holds. She would otherwise be entitled to PSI. I don't know if the defense is waiving that or not, but I would, if we already got sentencing, other than the waiving of PSI, it would need to be referred.
Do you want me to order a pre-sentence investigation?
Yes, please.
Okay. All right, so we'll order a pre-sentence investigation. They usually take about 8 weeks, so we'll just reset this for about 8 weeks' time. It's going to print tomorrow anyway, Mr. Tomas, because we're after a cutoff date for the clerk of court. 8 weeks from now puts us roughly around Thanksgiving. So I'll just ask for the pre-sentence investigation to come back the Friday before Thanksgiving, the 21st. Is that all right?
That's fine. I can make myself available.
That's just for the return of the PSI. It's not for actual sentencing itself.
Yeah, that's fine.
Okay, so 21st is the next court date for the return of the pre-sentence investigation. If it's back then, we can pick a day for sentencing after we get the pre-sentence investigation. Is there anything that I need to address from the parties before we adjourn for the day?
I don't believe so.
All right. All right. Thank you all. We're adjourned. I can sign it tomorrow. Umberto.